Last week I had already mentioned before Lordship.
Why it is not coming when he is mentioning since last 2 weeks? Pass on the memos, all the memos. Please give all the memos.
I have a specific days required.
Please pass on the memos. It will be there. Don't worry.
3rd of July.
What can you can't let us see the functioning of the court should be left with the court. Let us see. Any difficulty you just mention, don't worry.
On 18th of June, I had 2 GST RC matter listed. 2 has different name of the different petitioners below. What has happened, the order was passed and in the order uploaded below, the petitioner name, though I had given the corrected copies below, the name is different.
Please give, these are the ministerial error. It will be corrected.
Yes.
Give. Why you mention the matter? Yes, correct cost title, correct cost title and the downloaded copy of the order.
Your Lordship, indulgence. Item 39 is the same tender which is the subject matter challenge item 1. Your Lordship already heard item number 1.
Don't worry. We'll take both.
Taken up along with that. The same tender.
Yes, we'll take. Don't worry. Yes.
Right. Item number 1.
And as per your Lordship's order, I had taken out notice, I have appeared with my counsels for the successful bidders.
My Lord, director on that.
4, 6 and 7.
Copies on the opposite.
4, 5 and 7. 4, 5 and
7. That we have done, and my friend is appealing.
That's beneficial for him.
My Lord, and on my behalf, my senior will.
Yes. Give me the hard copy. Yes.
Just to remind your Lordship that your Lordship had seen, because initially your Lordship asked a very pertinent question that no order has been passed against me. So they, in their counter at page 34, they gave the decision. Your Lordship were examining that decision, page 34.
I just forgot everything because I do not carry anything with me.
But I'm sorry, may I just recapture?
Can you recapitulate the fact, please?
I'm sorry, I'm just. But the petitioner is an NGO. The municipality, Bhubaneswar municipality, they float tenders for the job of door-to-door collection of waste materials. So that job was there. In 21, I became the successful bidder for 3 years and it ended in 24. October. Because the next tender process did not take place, I was being extended till, and the last date is today. Your Lordships have been gracious enough to put it today, because today is my last day of the tender. Now, so far as the second tender is concerned, it had a schedule. I had shown the schedule. Your Lordship kindly, I'm sorry for repeating it. Page 104.
Yes.
I'm sorry. Page 93. Sorry.
Yes.
Page 93. There are certain, your Lordship sees the categorizations and certain dates have been given. All have been followed. Now, Lordship sees item number 3, submission of pre-bid bid queries latest by bidders to email so-and-so 1710. This also we attended. Raised some queries. They issued clarifications and the proposal was submitted. Everything was okay. Last item, your Lordship sees date and time of opening of proposal 5/11/24. But after this, they remained ominously silent. They did not reveal what was the outcome of my proposal or what was the outcome of the entire bid. So we represented and we waited, and in the meantime, they have been extending my tenure, which, sorry to repeat,
Until the finalization of the tender. Yes.
Now, I came before your Lordship when on 16th, they issued a letter that your
16th means what?
16th of June,
June, which is a page.
14 page 263.
263. Yes.
262. This letter they issued on 16th of June, stating that you are hereby directed to complete handover possession by 30th.
Correct.
So this made me to believe that nothing has happened, nothing had precipitated in pursuance of the bid, and they have ignored it. And I reliably learned that 4, 5, 6, 7 opposite parties.
No, this was very, they conveyed a very laudable message
Yes.
there.
Yeah.
That they have already finalized the tender.
Yes.
And because of the finalization of the tender, your work is no longer, because you are not a successful bidder. So you complete it by 30th of June. No difficulty, because the second line is there.
I filed the writ petition on 20th.
Okay.
20th. But in the counter-affidavit, but my point is that they have not issued any communication to me about the outcome. That is what our stand was. But that stood no problem there, because in the counter-affidavit at page 34, they have given the decision. It starts from the minutes of the meeting. It starts from page 30. Proceedings of the meeting for this evaluation of this bill. And page 34 is item number 7 is our matter. The appellant has submitted its work experience under IEC and support for door-to-door for instance, almost solid waste into top 20.
Oh, this is that matter where you have submitted till October.
Yes.
They wanted a fresh audited, this was the extension of time. Where is that? Now I can recollect everything. Where is the extension of time?
Yes, those two letters your lordship sees at the page. Page 254. Page first. Lordship got. They first was in inviting reference to the subject cited above, and upon evaluation of your application submitted in response to RFP, read with amendments made in previous clarifications to that offense, it is observed that the demonstrative minimum eligibility criteria as prescribed in clause 532 states that
Clarification was sought.
Yes.
Then within the time, that is 7th of March.
Yes, and next
Where is your clarification?
256, page 256. 258, sorry. I'm sorry. Page 258. I gave the clarification within time on 6th. 6th.
Yes, he was trying to take advantage of an accountancy system.
Correct. So,
Now I remember.
so therefore, the deliberation under that item 7, which the consideration while taking my bid as non-responsive, I submitted before my lordships, your lordship's observations were also there, that they cannot travel beyond this, because what they have decided under item 7, that is the reason. And nowhere it is given reason. They wanted to make out a case that.
Please show me from the terms and conditions of the NIT that you are supposed to give an audited balance sheet up to 31st of March.
That is the only requirement which they have quoted.
Where is that stipulation? I just wanted that conditions in the NIT.
It starts from page 7.
No. This NIT is from 93.
Yes, no, 93.
Where is that? The conditions?
Page 7.
That 54 lakhs or something.
Page 19, for the equivalent case, running test.
Should see page 115. One.
It's good. 6.2, technical evaluation criteria.
Clause 3 is the late court, which was revised subsequently to 50 lakhs. It was earlier 1.5 crores. Lordships may see serial number 3. And
Where is the revised?
and
206.
two, your lordships, the last
Where is the
line.
revised one?
206.
But pausing here for a moment, your lordships may also see
No, let me
clause 2
see.
of that where.
I will see to it first. Let me see 206.
206.
Yes.
206. That was enhanced to
Reduced
reduced to
50 lakhs.
50 lakhs. So,
Along with that, submit a certificate with valid use.
so what they wanted under clarification under Annex 12, that Lordship has seen, is that
There is a two stipulation. Clause 2 also talks about the average turnover of 7.5 crores during the 3 financial years.
Yes.
So
But
that you,
they only wanted this part. Page 112.
no, I understand what you say.
Yes.
They insisted for this 50 lakhs.
Yes, that's all. So the confusion was, you have given it till October, but
Give me till March.
yes, give it till March, because if March you may be less, as your Lordship rightly pointed out that other day, that it may be less. So I clarified, no, by March also my net worth was this. Now they wanted to bring out, the municipal council wanted to bring out the case that it is a different proposition. You are giving one certificate and another, and the certificate is given, certain items are not correct as per this. But my only submission was, subject to your Lordship's consideration, that page 34 is the consideration. They cannot add or subtract any consideration now before the Honorable Court when the case is sub judice. So at page 34, these are not the deliberations.
34 of
the counter.
correct.
These are not the deliberations. They only say that it was, may I not be permitted to repeat placing that. The applicant has submitted.
So no, I understand. You're taking an advantage of the situations that once the authority have taken a particular plea at the time of rejecting your bid, at the bar, they cannot improve something more. I understood, but sir, from that particular MS Gill's judgment, you are just referring
Right.
and you are taking advantage of that. This is what your bone of contention. We appreciate it. So now they have said that this is the situation. Now clarification, what does it mean? Because the language which is used in the letter
Well,
seeking clarification is very ambiguous. Does it invite a fresh document to be submitted, or does it require only a clarification?
but my humble submission is, no, they could have stated, if, as your Lordship rightly permitted, pointed out, that they could have rejected also. They could have
That's
rejected.
true. That's true. That is what I am asking, that this clarification
Is only
letter
limited to
which
this.
they are relying is very ambiguous.
Yes.
It does not really talks about the same.
That is the only clarification they want, and I confirm.
Can they?
Lord, that
The
is
second question is, can they extend the time?
extend.
This is because the submission of a bid was already
Yes.
notified
Yes,
by giving a date.
yes.
If you submit it on a date, then it has to be considered as
On that,
as is, where is basis, what you have already included. Now, if it appears that your document on a technical ground is not in consonance with this, they could have taken a decision whether they can extend the time and ask for a clarification in that regard. if they can, then whether the clarification means submission of a new and fresh document.
Lord, my humble submission, it is not a new and fresh document. It is
This is
merely
definitely a new document because your audited balance sheet was up to
Till
October, and now you have given a balance sheet up to March,
March.
which is in conformity with the requirement.
Correct. And what
So
is
in that
event?
event, whether the submission of a new document in the garb of a clarification is permissible.
That what the humble submission is that they could have in the meeting or in any letter.
Because the letter is not very specific that what we have found, please clarify whether your net worth
Yes.
was there even as on 31st March. They could have said so.
But that is what I clarified. Not whatever they ask, that's all. Not I cannot improve what they.
Where is your forwarding letter? When you submit that 31st March audited balance sheet? Five zero.
2558.
What is this? What is this clarification?
This is the submission of clarification.
Where is the clarification, sir? What is expected when a clarification is sought? Is it not that you will give some explanatory note to it?
But this is what has been with reference to the subject cited above. I am here with
In closing with. That doesn't mean.
clarification for the work of selection.
What does it? Is a clarification?
That till 31st. This is.
I am asking you, sir. You are an officer of the court. You know the law very well. When anybody asks for a clarification, do you think that the language which is used is a clarificatory in nature? It's a submission. I am hereby submitting a fresh document. They did not ask for a. That's why I say this clarificatory letter was very ambiguous.
It should have been written that I had
That
given.
says we have submitted it as we perceive that as on the date of the submission, the net worth has to be given. We did not. You asked for a clarification. Even my net worth is more than what is stipulated in the tender document. I am for this clarification. I am just giving this one. This one I do not find anything. Enclosure.
It could have.
I hereby throw you. That means a fresh document you are submitting.
It could have been worded in a better manner. That
Are you not submitting a fresh document? Can you? And the very basic principles. Can a rule of a game be changed after the game is played?
No, I am not.
This is what is.
I am not changing.
A gentleman who does not have the net worth or who perceive that I do not have that particular may not apply.
No, I had given it for an extra time.
No.
That's so I limited.
Not so easy, sir. In a tender, what is the importance of fixing a date?
That is
What is the importance of fixing a condition?
commercial transactions.
In a technical
But
bit,
the question here arose that this is the reply which I had given, indicating which it means.
Sir, that is why they say that the requirement was up to 31st.
Yes.
You did not submit any document which reflects that on 31st your what was there. Now you have submitted the fresh document subsequently cannot be accepted.
But that if they would have to that note, if they would have deliberated in that manner.
This is what a deliberation comes.
Item 7.
Yes, please look at this is what a deliberation is.
The committee then referred to. Lordship is reading.
It says committee noted that the applicant has submitted such and such on such and such where 31st of October, whereas the stipulation required the net worth as on 31st of March. Thought for a clarification in this regard.
BMC
In response, he submitted a fresh certificate. What does it mean?
You should, no, that's what I'm saying. If this is a violation, it could have been rejected on this ground.
But
But
that is what is there.
but the
Says the further committee also referred the provision laid down in such and such. This committee had then referred the provisions laid down in 5.4.5 of the manual issued during evaluation, the comparison of the bids, procurement entity
this
made
is-
discretion, asked the bidder for clarification. The request for clarification shall be given in writing by a registered post such as. As per the above, the committee resolved that the claim made by the applicant for meeting the eligibility criteria WRT, I do not know, with regard to, I think, the net worth cannot be accepted.
that is the provision under which they asked for a
When
claim.
a harmonious reading of a or the letter is required, then you cannot segregate the first paragraph. That what for the clarification was sought. You cannot, you have to read it conjointly. You can't leave it that I discard the first part, look at the second part. No, it has to be read as a whole. So intention is not very expressive,
That's-
but the intention can be reasonably gathered that what they really wanted to say.
That, but the fact remains, at the end of the day, it is 1.5.
Whatever.
No, that is the
Whatever.
that is the only.
I was just looking at it that if you perceived, I can understand that you perceive the clarificatory letter in this manner. What you are now contending.
It has been.
I would have understood, but your letter,
It has been loosely worded.
no, sir, not loosely. Is bereft of any
It would have been written in a
expressions.
better manner.
No, sir, bereft of any expression, sir.
Would have written that I had submitted, so the.
No, this is how I perceive that this is what a clarification you require. I am now giving that clarification that even my net worth on 31st of March is this, and in support thereof, I am submitting you this document as well.
In substance, it means that. But maybe loosely.
Can any reasonable man would gather this? Can any reasonable, with reference to the subject cited above means submission of clarification for work, I hereby enclose the clarification for work of such and such, along with the associated I's, categories of.
That means you wanted till 31 March, so I am giving it.
No.
That is all.
And the clarification is enclosed, that's another certificate.
Yes.
No.
Another certificate means till 31st. Till 31st.
Not that document. It's an independent document.
So therefore, the intention is that it is, even if you take till 31st, it comes within the parameter.
What is the ultimate, what is your case? You are a successful bidder or unsuccessful? Again,
Sir, my
unsuccessful.
my technical bid has rejected though. For two
Which
parts,
serial number?
39.
No, this serial number means of the resolution,
No, serial number. If you are
of the resolution.
kindly turn to, yes, the decision, because it was never communicated to me. Sir, it was-
Whatever, first let us see on what ground they have rejected.
Sir, kindly turn.
You are what? Mrs. Vikas or what?
Page 446.
Who are you?
Sir, page 46, social activity to health advance.
Which one? What
Page
exhibit?
446, year number 4.
No, sir. I wanted this from resolution. There are several bidders
Yes.
whose cases were considered. Who are you? Are you coming within that?
Actually, Mrs. Saha, that
Mrs.?
social activist health advancement.
Oh,
They are-
you are Mrs. Social Activist and.
Yes, bro, health.
Yes. Let us see. Serial number 4.
Four. In there,
Just 1 minute. Just.
I have been found to be responsive.
Just.
And thereafter, I was called to give a PowerPoint program to demonstrate, sorry.
So your case was considered in the technical bid.
Sir, succeeded technically by two parts. What the last part is, I'll show you, Lordship, last part is marking. So marking they give as per the interview. Interview in the sense a PowerPoint program. So I'm a continuing NGO which is continuing to operate.
Sir, you participated with the open eyes,
Correct.
with the open mind,
Correct.
that these are the procedures which would be adopted.
Yes, ma'am.
If the procedure prescribes that what they are supposed to do, and if they have done it, then in that event, can you now take a rebound and say that this is what,
I'm challenging the decision-making process.
can you? That freedom with the tender authorities are there.
Sir, the decision-making process can be challenged. You know, says no Tata Sons.
I'm quite conscious, not the decision, but the decision-making process. I understand. But what is the decision-making process when you are saying if the requirements are already evident from the NIT?
If your Lordship wants to pay 78, and so that my brief.
78, what is that document?
Sir, 78 shows that these are the points you can get. If you get 75 marks out of 100 in the technical bid, your price bid will be open. But they have given me mark 64. So that's 64. But against each individual column, there is a mark. I have satisfied all the columns. If I satisfy, they cannot do it. It's like mathematics. If I do correctly, I have to get full mark. If I satisfy the requirement of the column, I'll get 6 marks. Then next column, 4 marks. Next column, 8. If I don't satisfy,
There is no point then in that event.
they can't reduce it.
No, that's the another thing. There may be situations that they have bifurcated, say the 10 marks, which is to be awarded as per the number of the work contracts which you have already completed.
So it is not that.
Then I am asking, just hypothetically. So if somebody has completed 10 work projects, so he may be awarded a 10 marks. Somebody has done 8, so he may be awarded an 8 marks.
But
So it all depends that how they arrange that particular marking.
It is correct. I accept one. If that would have been so, I would have a case. I don't have a case if that is so. But you can also
The item number 39, 38.
Yes, 78 or should be of my read.
No, that is the NIT criteria.
Yes.
Where is the awarding by you?
So the NIT criteria should be kindly first see.
So that is what already there. They have identified that up to 7.5 crores will be and 10 crores 7 marks. Then more than 10 crores 10 marks. This is what I said. They have done that.
Right.
So
Can you just take your page 78?
I'm looking. This is the same document which he took me to.
The technical evaluation criteria is, and here they say the applicant must have supported one formal local body on door-to-door waste collection transport along with IEC the information to continue during the period of 2 years for the last 5 years from the bid due date with a minimum contract value so within a period of 2 years and a single contract in a municipality which has ranking of 35 2023. Then above mentioned experience, 2 will be 20 marks, 1 will be 15 marks. So I have satisfied 2, I'll get 15. They cannot deduct it, make it 12.
No. If
Then
you
next-
say,
next-
if you have 2, then you will get 15 marks.
15.
And if you are more than 2, then you will get a 20
2
marks.
will get 20, 1
No.
is 15.
Acha, 2.
2 is
Yes.
20,
Correct.
1 is 15.
Correct.
But then next is minimum average annual turnover. If that is so, then 7 marks, it is 7.5 to 10. If it is more than 10 crores, 10
10
marks. So these are all mathematics.
Absolutely.
But what they have done, they have reduced these marks, though I have qualified, satisfied all those things.
How reduce this means what? What reduction?
They have something that out of 10, they have given 8.
No. One thing is that this particular
These figures cannot be
this
reduced.
particular marks
Sir,
which they indicated at the time of floating the tender.
right.
Now, these marks have been reduced by subsequent corrigendum or by subsequent
No,
notification.
I satisfy the corrigendum.
Now your challenge is awarding of a marks to you.
Correct.
Your challenge.
Yes.
Show us that how they have awarded a marks.
You have mentioned it. In the
Where? Show us. I do not find.
Counter-affidavit that pays 445.
Counter
Reject
is
the one.
filed here.
I have given a sample also in my result. In the counter-affidavit, kindly turn to page 449.
We have no chronological number. Can you please tell us the counter?
Say inner page 117. Correct? I'm sorry. Said that counter inner page 117.
Yes.
Running
We
page
have the, where is
449.
the counter? I just wanted to find out.
Running pages. Sir, page 117, let's me turn. 117.
Of the counter.
Of the count.
Yes.
This is out of 60, they have given me 44. They have not given the breakup. But they can't give 44, they have to give 60. Reason being, all those columns I have satisfied. They must, this is what they have committed actually, this non-application of mine in the decision-making process. But the second person has given 65, got 60. The fourth person has got 60.
Oh no, 53. Fourth is 60, yes.
Yes, but on the what basis actually they have been given 60 when I satisfy all the basic requirement. Marking schedule they have given in their table, in the NITs, I have satisfied everything. Out of 60, I should get 60. 44 is absolutely incorrect on the face of it, man. No reasoning has been given. Then, sir, kindly turn to the next page also. Out of 40, they have given 20. But these are all, but they didn't allow me to give a PowerPoint program because you are continuing NGO. I'm still continuing well in most of the awards. Sir, because my satisfactory work, municipality ranking in all India basis has been risen actually. So far the smart city marking is concerned. In the result, I have given a table actually where I also indicated how much mark I should have get the base of their own table.
No, I do not get it. If we go by a simple mathematical calculation, it does not really appear that the 60 marks which you are really contemplating is talking about. Now, position is if you come to this technical evaluation criteria,
Right,
which you are referring,
right,
the first column total number is 20 marks, which is awarded.
right.
70.
Page
Second
78.
column is a maximum of 10 marks, which is allotted. So 20 plus 10 makes a 30. Then the third column, maximum 10 marks is allotted. So 30 plus 10 is a 40.
Right.
And then another third column is also included. The third column, which is of 20. So that would take us to 60.
Yes, correct.
Correct.
60.
If I take it 60 in this way, then please come to the fourth column.
Fourth column.
Is a technical presentation, which is earmarked for 40.
Yes.
Totally correct. Technical presentation varies. But if we take all the marks together, then it will be near about 100 marks.
100. Total is 100.
Now, what 60 they have taken? Is it the second, third column and the fourth column, where certain leverage is given? And then they evaluated it? Is a question which has to be considered in this way.
Your Lordships may see page 38 of their rejoinder, where they have self-evaluated itself
In
I have said-
in accordance with the tender
60,
bid document where the
I've
marks
said
are
now-
less.
I can understand what you are saying is that so far as the first column is concerned,
Right.
the moment your experience is in respect of 2 ULB,
Right.
you are straight away awarded 20 marks.
And
There is no discretion left to the authorities. Secondly, if your minimum average turnover exceeds 7.5 up to 10 or exceeds 10 crores, then you are straight away awarded 10 marks.
So
No,
I have self-evaluated. I have given a table also.
I'm telling you.
That comes to
Now-
49 out of 60.
Now,
If at
I'm
all there is reduction.
again saying that the first column, also there is no discretion which is left on them.
Yes,
They have to award.
right.
But the discretion appears in a second, third column and the fourth column.
Second and fourth.
Now, there are 2, 3, third column.
Yes,
I'm talking about the second, third column.
well, got it.
You got it?
Yes,
The second, third column and the fourth column, the discretion.
right.
If you take that, then it will take out you to 60.
Correct. Correct.
What they mean by this technical marks out of 60? Do they mean this second, third column and fourth column? Or first, second and whole of the third column, which will take us to 60?
So I think they must have done it whole of the third column, in fact. 1 to 3, there is no question of any reduction.
Then it comes to 60.
3 actually out of 20 they
Then
have
this 40
deducted.
has to be ruled out.
I would have get 49 if I are
If
given
we
a
take the
self
second, third
assessment
column
also.
20 and then 40, then it comes to 60. So this is how the evaluation has to be.
And interesting,
And this is what it says that say approach and methodology through technical presentation. The presentations have been made by depends. Next question. One presentation is very good. No, sir. Even the total marks which is to be awarded is also appears to be wrong. They could not have evaluated on a 60 marks, but on 100 marks. 75 of the 60 is a larger one than the 75 of the 100.
Sir, if your lordship kindly turn to page 440, 117 again.
No,
That is incorrect.
because if you find after this column, they stipulate 6.2.2
Yes,
that to qualify for a next round of a bid,
right.
you must obtain 75 out of 100,
100.
not out of 60.
No.
May I clarify subject to your lordship?
I will come. First thing is, let me understand what he is.
That is exactly.
Not
what
to
the
be
tables-
swayed by the expressions of the judge. Always camouflage. So you are really concentrating on that. Your contention, if I correctly understood, you say when there is a earmarking of the conditions and those have to be followed rigidly,
Right.
you cannot relax it. There is no question of anything which to be done. If I have done it for 2 ULB, I am entitled to 20 marks straight away.
But if I would have qualified in this, then I would have my financial bid should have been open. But my financial bid is absolutely at par with the lowest person actually which is given. So that would have given a financial benefit to the state exchequer also.
That's the only thing. That's the only thing, your
Sir,
point. There is
sir,
another
one
point.
more document I would like to show. So kindly turn to my rejoinder.
It is the review. Yes. Huh? No. Huh? Oh, sorry.
The page, inner page 39. Sorry, inner page 38.
Annexure 14. Annexure 14.
What that document is?
Annexure 14.
What is that document?
Actually, a self-assessment of
Okay.
the mark.
That will be page 539 on your lordship, sir.
Yes,
Really, 491.
Yeah, sir. Running page.
In a tender matter, it is better to have a physical copy because many a times you'll have to hover around here and there. So that's why I asked. And putting certain documents here. There. Annexure
So kindly-
14. 14.
Annexure 14. Page 38.
Yes.
But I have given this second column in the item number 1. I have mentioned experience of 1 ULB, that is 15 marks. I should get 15 marks. So total I should get 49 marks. Education, qualification, all those things are there, experience and qualification.
You have correctly assessed your presentation to be an excellent par excellence.
Sir,
It has 40 marks.
So what has given in the presentation, they say you need not give PowerPoint presentation. I'm indicating my record because I'm a running NGO who is continuing. now.
Whatever your authorized
But
officer
I
is
have given-
supposed to.
But kindly turn to one document. All right, I will not say what I have given. It is there on record. Kindly turn to page 291. Page 291, annexure 12. Annexure 12 is my read.
comes down to this 20, then the total marks will be less than.
And also I get 75. If not 89, I can get 75 minimum. But I'll show you also page 291. Page 291. One more document. For Lordship's appreciation, my lord. Kindly have a look at one more document.
Page?
291 in the replay.
Yes.
Sir, these are the PowerPoint presentation I had presented on the table before the committee. Trying to look at what the things I have done and what
Is the court expert as
I'm
an
not
expert?
saying that. What I beg to submit,
So
my
it
lord.
is better that your presentation, whether it is in, I would say, what they really intended to get, whether it fulfills those aspirations or not, is within their domain. In an interview also, when marks are awarded, you can't come forward and then say that I have done wonderfully well. So how can I be given a 7 marks out of 15? I have done it. These are not. That can't be. We
Your
can't.
Lordship is well aware of the fact where actually interview and all those things are deprecated on the Supreme Court saying.
No, single. What it says that selections purely on the basis of an interview
Right.
was deprecated.
Arbitrary.
You can't. This is arbitrary. There is a
But here,
very likelihood of the nepotism, favoritism, I can understand. But here is not that case because the several criteria, even in interview is a very important facets. If you earmark, otherwise,
I have indicated in my written application.
how can you evaluate yourself? Everybody, when he writes the answer to the question, says, I am the perfect.
What I beg to submit for not say.
Can't. How can we say presentation is correct or presentation is? We don't have a technical knowledge of it.
Expertise.
It's a specialized work which the authorities are there to assess.
Definitely. Because objective words, particular things, no particular manner.
Correct. That is up to them.
Limited to their
Said we can't.
limited to their
So we have not self-assessed, but so far this is concerned.
This is what a
We have
self-assessment of 40
indicated-
marks comes.
40 marks is there.
So you are given a 40 marks.
No, I said maximum is 40. But if I get,
So it may be 20. If it is 20, then you come less than 75.
if it's 20, I'm less than 70.
That is what I'm
The
saying.
question is,
So you can't say that what they should award.
but here actually, if somebody wants to delete me from the consideration or they ignore me. but they
You
can
know,
give a
you
lesser
know
mark.
better, but the decision of the courts are very uniform in this regard.
But I'm confident of it. And that's the reason why I say that they have not applied their mind. The decision-making process is wrong so far as the
So,
evaluation.
sir,
is
if
concerned.
there is something else, I can appreciate it. This is what they have done out of 60. They should have evaluated out of 100. So let us ask whether there is any corrigendum, there was anything which they have already published.
Right. That also.
That is what I wanted to know.
That's also not corrected.
So let us see that how can you evaluate.
And interestingly, I'm the person they are satisfied with my work and I'm continuing. And I'm continuing till today. And I have the manpower, machinery, and everything. If I have done anything wrong, they would have terminated my contract. They would not have
Why?
extended.
Why they will?
But this evaluation is arbitrary.
Let us see how far we can go. Any judgment you want to cite is the court of your contention.
That judgment also just indicated that arbitrariness in case of simple interview, that judgment is there.
So it's only purely on an interview. It does not really talk about anything. And it says that higher marks in the interview is also deprecated.
It's not
But it is less. I know two judgments, two line of judgment. One purely on an interview basis deprecated.
Yes.
Secondly is that giving a lesser marks in for other criteria and higher marks in the interview is also deprecated.
This is the decision you also have to difference.
So these are the two line of judgments I am aware of.
Yeah, the government actually set aside it. That was challenged for the Supreme Court. Supreme Court said, no, the decision is correct because simply on the interview experience.
No, simply on the basis of the interview, no doubt about it.
Right.
I'm saying so.
Exactly, I said, but your RC indicated.
No, that is correct. No doubt about it.
And here it has never been communicated. What they have done, they filed a caveat. No, it was never communicated to us.
What?
Petition. After this technical bid was, my technical bid was rejected, they opened the financial bid, they filed a caveat. A copy was served on me, as if I should be the aggrieved party. But they never communicated the decision. Non-communication itself is, the process itself is used. It has never been communicated. If you have taken a decision, you should communicate. Reasons are also correct that you have to also give reasons why you are rejecting. That has never been done.
That's all?
That's
Which one you want to? Who is for the municipality? Which one you want to take first? His or his? We have heard both.
First.
So what do you want to?
No, let us-
Item number 1 or item number 39 first?
I
Tell
think
me.
39 since your lordship.
Is a recent. You can take 39 first. No difficulty.
Hello, lordship will look at page 17. The pre-bid evaluation, page 78 of the petition.
Kindly tell me when your conditions in the tender document, NITs, talks about the evaluation on out of 100 marks. Then evaluate out of 160.
So evaluation, that is, so far as the pre-evaluation, so 40% mark has been specified for the presentation. 60% is.
Where is when you say they have obtained certain marks, say
Out of
44
60.
marks out of 60.
Out of 60.
Correct? No difficulty, 44 marks. If out of 40, if you give them 40 marks, will they not exceed 75?
Yes,
So where is the evaluation on 40 marks?
the 40 mark evaluation, that document I have not filed, but the lordship.
Then
will
why
see
you have
the
not, then what is to be done?
40, the marking system, the lordship will see that is 44 marks have been awarded
Out of?
out of 60.
How?
60.
If you come to page, your own tender document.
Yes, ma'am.
If you come to clause 6.2.2
Yes, my lord.
at page 116 of there.
Qualifying technical score,
Correct.
page 79.
Correct.
Qualifying technical score for opening of financial bid is 75 out of 100.
Now
Based on
tell
the-
me how you have done.
Well, that is that your lordship will see the 40% mark we have given.
No, it does not talk about the percentage basis. I can reasonably infer what you want, but it does not. If you take off 75% of a 60 and a 75% of 100, it will make a difference.
Yes. But here, my lord, it is 60 and 40 specific marks have been specified for.
Where
specific-
is the marks allotted for 40? Somebody may qualify.
Sorry, my lord.
Suppose a person did not acquire 75%,
Yes.
though you are not required to give, but we can reasonably infer when out of 100 you talks about any marks, so we can reasonably infer it is a percentage also.
Yes.
Same difficulty. Now tell me that suppose if you says 75% of 60,
Yes.
one got 70% of 60. Let us hypothetically examine. He may get 80% or 85% of 40. If he gets it, then if the 100 is to be calculated, he may exceed 75.
But that is not
He
this,
may
that,
exceed.
yes, but that is not there in the tender document. NIT is very clear.
Where is the clear is there, clarity.
The 70
But your action is
not percentage.
creating a
It's not a
confusion.
percentage, 75 out of 100 is there, it get very clear. 75 out of 100 total mark.
You just gave that out of 100, you did not get 75% marks. It is an open and shut case. We will throw them out of the zone of consideration, no doubt.
Yes.
It is up to you how to give a marks. But 60, how can you give?
Lordship,
Can you change the conditions of the NIT after the
No, but-
participation is done?
No, my lord, you have not changed the conditions of the, because you have,
You have to award marks out of 100. You have awarded marks out of 60.
no, out of 40, you have also marked awarded.
Where is that? I just wanted to know.
That part, my lord, you have.
Please show us. I wanted to know that.
So, but that part, your lordship will see, page, counter-affidavit, page 118. Counter-affidavit, page
118
118.
of 39.
Page 118, counter-affidavit. Item 39.
I understood.
Item 39. Item 118. Sorry, page 118.
The last one I am getting 60. Yeah. Yes, sir. 10. 180. Sure, sir.
The social activities for health, that is the picture
Oh.
in this case.
Yes,
Yes,
you have awarded.
Yes. Commissioner, the total award average mark is out of 4 because each.
They have given you, they given a 20 marks to him.
20 marks to him, average mark is 20 because all the interview committee members have assigned specific marks and average comes to 20. Out of marks out of 60, 40, 44 and total 60.
It was not good. I got your question.
Hello, because the 40-point mark is specific.
Sir, the confusion was very clear. That's why the senior counsel was absolutely silent on this.
So, my lord, that and if you also look at his own regional also, he has himself self-assessed the mark. That also he has awarded 49 out of 60 himself. Even if let us accept his calculation, 49 out of 60 and 20 out of 8. That will also be page 38 of the regender. Page 38 of the regender. Page 38 will also be annexed 14. Yes, stated here, but he has
Yes. That's all.
self-assessment. He has given self-assessment. 15, 7 also 2 he has given complete wrong. The details of the marks because we have awarded marks 44 as per the mathematical calculation, there is not. So even total, even as per his own saying, but there is a difference, he would have got 5% more marks. Sorry, 5 more marks. And 20 marks is, he himself admits that he has got 20 marks out of technical presentation out of 40 marks. So total 49 plus 20, 69. As it is, she is not coming below 75. Your Lordship, I can also show the.
What about the,
Yes.
In my case, can I just give one reply?
we'll come back in reply.
Right.
Let us, that's why I invited both of you to argue first, so that we will meet.
Sir, sir.
Yes.
So far as,
Why you gave a letter seeking a clarification?
clarification letter, actually.
That means you did not finalize the entire tender process within the time indicated in the NIT.
Actually, the procurement manual is being followed. That is the reason procurement manual pays for clarification. That is the reason clarification, as Your Lordship has rightly read that portion. And the clarification, what he has done, he has given on the document that.
Don't
document,
go by what we observe.
No, I'm not referring to Your Lordship's observation. And my submission, my lord. He has submitted a fresh document and he has consciously suppressed that fresh document. Even that fresh document is also not acceptable. Your Lordship will kindly pass from our counter, my lord.
Because
our counter.
it
The financial statement he has
contains
given
a posterior date.
posterior date, and that is also not permissible. And even if it is, let us suppose it is permissible, but the Lordship kindly see their own counter. Sir, my lord, we have given our counter wherein he has submitted whatever documents he has submitted, we have given in the counter. Lordship kindly see our counter. He has submitted along with the representation.
No, we have gone through that.
Yes.
He has submitted those 6th March audited
No, that
balance sheet.
audited balance sheet also doesn't come within the 51 lakhs is also not there. It is contrary to his own, the very same chartered accountant has stated something different in the audited balance sheet.
No, it exceeds 50 lakhs.
No, the Lordship will see.
Your junior was, I think the assisting counsel was trying to make us convinced on the accounting system.
No, accounting system, that is a total, but the document he has filed along.
Assets, liabilities, all he was talking about.
No, my lord, the Lordship will see from the. I'm just from the counter, we have filed the document which he has filed along with the supposedly clarificatory document as a way of clarification, my lord. Lordship kindly see the. Yes, my lord. Lordship kindly see our counter page 27. He has submitted only this document, not the subsequent documents he has not filed in the petition. Writ petition, he has filed only this document, not the subsequent documents which he has himself has filed it along with the clarification document.
What is that?
My lord, Lordship kindly see page 28 of the counter.
Audited balance sheet.
Audited balance sheet.
Yes, he was referring that audited
No, audited-
balance sheet from the other.
No.
Where is the counter? No. Oh, this is a counter. Page?
Page 27 of the counter, my lord.
Yes. Yes, sir.
First, your Lordship will see page 22 as the original, which he had submitted earlier. But subsequently, after the clarification, he has submitted page 27, my lord, kindly see.
Yes, that is up to 31st of March.
31st March, then your Lordship kindly turn to next page.
Yes.
This document he has deliberately not filed before your Lordship. Page 28, your Lordship kindly
Yes,
see.
that is the computation. Balance sheet.
The unsecured loan, here, my lord, it said that there is no loan. Bank loan, unsecured loan is big.
Your junior pointed out, then I invited his attention to accounting system.
No, account.
I think the chartered accountant would be able to satisfy the conscience of your client. Your associate.
My lord, but
That what is required.
it is writ large on the document itself.
it's not so simple because the accounting system, he's not aware
No.
that what pattern we adopt. It differs what the accounting system which the other country they adopt,
But
is not the same one which we adopt.
that,
The losses will see the next page as 29, which is the schedule that has been given. If a losses should
that's
see
the document itself.
29, your losses for a moment. If a losses should see the total, the scheduled fixed assets and depreciation is 25,26,992.
True.
Yes, which matches with the previous page if your lordship should see 25,26,990.
These are,
But in the certificate, if your lordship should see.
it is required. You
Yes.
do not know.
But in the certificate, if your lordship should see, the same things have been added again. If your lordship should see from
Whatever,
schedule one,
whatever.
this furniture, fixtures, this books, everything has been added again in page 27.
Yes. That is the next net worth.
Net worth, yes.
It
Net worth,
depreciated-
there are- How can a
Sir,
consequent
sir,
loss?
every movable articles has its
to be
value.
included.
So at the depreciated value, if
So
they
that-
say that as on this day, it has to be like this, then how can you? That's
So
a,
that is there. I don't deny that
So-
figure. That amount is 25,26,992.
no difficulty.
But thereafter in the certificate, if your lordship should see, which has been given, immovable property is 30 lakhs 85.
Correct,
Then the movable property.
correct.
So now if your lordship should see the schedule 1 includes all at page 28 or 29. All these.
We clapped on the document, face of the document itself.
Everything has been there in that schedule 1, on the basis of which the first entry is made in the fixed assets as per schedule 1. And in this certificate, it has been repeated twice. Again, it has been added to make it 51. I'm not on the unsecured loans, my lords. Only that figure, if your lordship should take it, pure arithmetic, my lord, that figure is writ large. So the certificate itself brings in the doubt regarding its genuinity.
And also, your lordship will say that page 168, 171 also the same thing. My lord. The minimum accounting system of the net worth will be deducted from the net. The unsecured loan has to be deducted from the net worth. That is the basic accounting system which normally we have
There
in
may
our own
be a
cases also.
situation where unsecured loan becomes a bad debt. Can they not write it off
No, but we have
and
seen
say
in our
not
own
my
cases
liability?
also.
Can they not? Immediately. If after the period of limitation has gone, they can write it off, saying the bad debt
That-
of his creditor.
that- So that is the reason why, because we have that also they have not. And you'll also be the white.
Balance sheet will not contain that.
Audited balance sheet will not show.
Then they'll say nil.
Because
They will say nil. Unsecured loan, nil.
unsecured loan, they will show it, but the thing is that that is not rated in the, and also lordship will see with that, no liability.
Sir, under the Companies Act as well, suppose if company is wound up, for any reason say that he is unable to pay his debt, then in that event, the unsecured creditors, they do not have any
They
right.
don't
The
have that.
first primary right is of the workers' payment, then the
But
secured,
payment,
then the secured loan.
priority payment is there, secured
Then
loan,
the
banking
secured,
loan, all that.
then last,
Provident fund dues, that,
fallen in the line,
all in
the
the
last
last,
one,
unsecured loan is
unsecured.
the launch is the last. Unsecured the loan is the last. But so they don't settle. Because as per Schedule 1, he is himself treated as my learned friend has said.
What clarification you intended? Tell us.
Because he submitted on the October 24, October, that is the reason why, because requirement was up to 31st.
So what you expected from them is that first thing is why you have submitted the document till 31st October? Or you intended that, yes, what is your net worth on 31st of March you give?
Yes.
What you intended?
Your Lordship may kindly see our letter.
Letter is very ambiguous.
Letter is,
Read the letter.
23, page 23. Inviting a reference to the subject cited above, even evaluation of an application submitted in response to the RFP, read with amendments made in pre-bid clarification, both under reference it observed that demonstration minimum eligibility criteria prescribed at clause 5.3.2, which states the agency must have a net worth of 15 during financial ending 31/3/2024. Your agency has submitted a certificate from Chartered Accountant clarifying net worth of as on 31st October 24, as against the stipulation made net worth of 31/3/24. Therefore, requested to provide a clarification not later than 5 p.m. on so, failing which it will be presumed to have no
Then
justification.
what clarification they will give? What clarification? Please
And
tell
last, it is
me
made clear that
if the requirement under the NIT was the net worth as on 31st March. If they have given a net worth beyond the date, then it's a technical fault, then you could have rejected it. What clarification you saw?
clarification because we thought
That why you submitted?
and justification.
And if they gave a justification that it was due to inadvertence, I have submitted.
That also they have not stated to suitable conditions are taken. As it is also made clear that mere submission of replies shall not be presumed to eligibility under the tender for the subject work. That is the statement you have made the last sentence. Clarification submitted to the following email ID. But clarification even so clarification we intended whether it is up to that. We actually 31st March 2024.
Or you just wanted that whether there is any typographical error
Yes.
in the date. This is what you
that though specifically stated so, but you have given the reason because you have given the 31st October, but it should be 31/3/2024. You should clarify that part only. So that part, that letter is clear in that aspect only. That only the limited aspect. Not first, I mean the procurement also doesn't entertain any fresh documents.
Yes.
That procurement manual is also very clear in that.
Yes.
No fresh document is permissible. And that also we have categorically stated so. Because no post-bid clarification as per 34 also will see. No post-bid clarification at the initiative of the bidder shall be entertained. The shortfall information document should be brought only in case of historical document which pre-existed at the time of tender opening, which have not undergone change since then. That is it. So that is that as per that document, even this document was not acceptable. Still, we have considered that, but we also referred to that committee referred to audited statement submitted by the applicant, but not able to tally the above said figures submitted by the CH certificate. Further, committee also referred to provisions laid down in procurement guidelines issued by the state and central government. Committee then referred to the provisions laid down in
Can you say
5.4.
you can ask for a clarification in terms of this?
Yes.
That's all?
That.
Now you, any of you?
No, since your lordship is hearing this, just one thing to point out to your lordship, that why they say that I have not annexed those communications which my aunt was earlier. I have annexed it.
At least, I'm not very much concerned about it.
Only, but I need not repeat, waste your lordship's time. But they have a provision for seeking clarification.
No difficulty. They have put it also
They have put
in the resolution.
that. Okay. And I have given, in my way, may not be, as I stated, may not be, but this is the clarification that he wanted till March. I gave it. That's.
Yes.
So that page 113, page 445, the decision they have annexed F by 2 in the counter. But this is not a proceeding of the committee. If your lordship looks at, this is a type copy. But this type copy has been given, but they have not filed the original document to show who are the members of the committee and how they have conducted themselves to assess it. This is one part of it. This decision has never been communicated, and your lordship wanted to know that 2017 volume 2 ILR.
If the order is passed and kept in a desk or a file, is no order in the eye of law, not communicated.
But here actually this has never been communicated.
What proposition of law you are citing? Oh, this is what based on MS Gill of the earlier judgment of the Supreme Court. MS Gill.
Sir, Mohinder Singh Gill also referred to here.
That is what I'm saying. MS Gill means Mohinder Singh Gill.
Yes, but here actually the court wanted to know it must be first communicated and must give reasons. If they give reasons subsequently, the counter affidavit that will not be accepted. You cannot enlarge the decision by developing it subsequently. But question is, it has to be communicated, it has not been communicated. Second thing, if you also can see, the manner of handling, I have been found to be responsive. They have already held, I am responsive as far as the technical bit is concerned. Once I have been found to be responsive, they cannot discard me. What they have done, the marking out of 60, they have given me 44, though which is also not correct. And they knew that what mark should I get to disqualify myself in the interview. That procedure itself is faulty. Therefore, the decision-making process is they now feel that X should be given or Y should be given, Z should be given, and these persons should be disqualified. So it is not that one person should be given. If I have experience enough, this would have given me a lot of words. And I'm continuing as such. That should kindly mark. Therefore, you cannot say my technical presentation was not up to mark when you found me to be suitable for the purpose of the job. But these are the specific things, Lordship, kindly keep it.
Consider it. both the cases are taken up together. As the challenge is thrown to a decision of the authorities. In evaluating the suitability of the intending bidder at the technical bid stage. I have started.
Both the cases are taken up together. The decision of the the submission of the vehicles. By November 2024. And of the was indicated to be done on the same day. The court company here. Before we proceed, the evening reports. Which we property, the salient facts. Noise from the respective of the values. As we look at the points. The common goal for rescuing the legislative contract. And what it can simply was given to the number of money for corporation. Associated and because of untimely quoting of the children. Before the exploitation of contract, the existing contract was not existing And last of such extreme release is the bill submitted by the requester. Is rejected by the authority on the ground on the release that the submission of the bill was not in conformity with people. Is reported in the same NIT dated 1st October 20. What in the law? Despite that. That one of the conditions is very nice. In the section, and I. That very better. Put submit the network. Of rupees 50 lakh. And on 31st March 2024. Undeniably. On Petitioner submitted the auditor's report. Along with the document. Indicating the network exceeding the section limit, but for the period up to 31st October 2025. Then the requirement under the said NIT board that we let me become a servant is network as on 31st 2024. A clarification letter of opposition. What is the case? Where is that clarification?
3.
That is a page of council.
Annex 12, 254. 254. Page 254.
Better the third part will be by the seeking a clarification over the discrepancies perceived from a document pertaining to the net worth. By saying clarification was court can be, notice the discrepancy in the auditor's report. In exercise of. No, I'm sorry, not in this, on the basis of. There is that resolution.
That's page 34 of the contract. Quoted in bold letters.
Section 4.5 of the manual of the government of which provides that at the time of evaluation and the composition of the bids, the procuring entity may ask the bidder for clarification in the event of ambiguity in our disputed relation. What is with an intent? The
258. 258. 63 to 258. 258. Page 258. Annex 13.
What will be the clarity was sufficient. And 625 depended the auditor's report. I think the same auditor's report, sorry, the report, the submitting the appending the auditor's report. In relation to a network as on 31st March 2024. The report of what's the state study. In that word. As indicated by the point of Thursday, on 31st March 2024. Seats. The base level, that is the picture. The meeting for technical evaluation or selection of an agency was held on 21st March 2025
And the width of the replacement was rejected as 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 was rejected as a new or further document post the last date of submission of the bill. Wow. Is unacceptable. He said this is a subject matter of challenge in the principal issue. So the next one. That is the fact. But this number settles up. The register is an existing contract. You got the existing contract.
Existing contractor is extended from time to time.
Same.
Of the municipal corporation. And the previous contract was extended from time to time. As the municipal corporation was not to initiate the bidding process, the tender process. And is operating till date. Pursuant to the aforementioned inviting tender, the representative of participated in the tender process and submitted all the documents along with the offer. Subsequently, the authority did not find the representatives eligible for the financial bid as does not meet the requisite qualifications in the tender bid, in the technical bid. The authority rejected the tender submitted by the requester as he would not secure 75 marks out of 100 in terms of clause 6.2.2 of the NIT. The challenge is shown on the decision-making process. Primarily founded upon awarding of marks in evaluating the suitability and the eligibility of the requester. So, according to the requester, the evaluation by the committee in awarding the mark is patently erroneous as there is no laxity given to the authorities in awarding the marks on each parameter provided therefore. And therefore, the action of the authority is tainted with malice. And it formulate a sense of favoritism and nepotism. In the contractual field. On the prospectus of the facts and as succinctly narrated sharing about the counsel for the respective petitioners raised an issues and urged the points. Facts needed in the respective petitions. But to achieve a common destination of awarding the contracts to the other bidder upon reaching, after rejecting their bid at the technical bid stage. Taking the plea of the requester, that is Mrs. B. HON'BLE. The civil counsel appearing for the requester, you know, something that the moment the letter seeking clarification is issued upon the requester, touching upon the auditor's report containing a date anterior to the last date of submission of an application. The moment that clarification is given, it is not open for the authority to reject the bid on any technical stage, technical bid stage, as the fresh document cannot be accepted. It is permanently submitted. The net worth as on 31st March 2024 exceeds the base amount as per as per the report of the same auditor. And therefore, such report cannot be discarded as a fresh document. Submitted after the last date of submission of an application. The writ petitioner perceives the language employed in the same clarificatory letter as if the authority wanted to know the net worth as on 31st March 2024. And if the same auditor has certified that the net worth exceeds the net worth fixed by the authority, there is no occasion to discard the bid, having not submitted strict conformity to the terms and conditions involved in the set at IT. On the other hand, the counsel for the respondent, counsel for the senior counsel for the okay. That the clarification was sought in terms of the provisions contained in the manual for procurement of works 2022. Because of discrepancies noticed by the procuring committee, which cannot be, which with an committee, with regard to the dates appearing there, which cannot be construed as second lease of life to the bidder to submit the new documents. The further subjects that the clarification was restricted to a ministerial and or clerical error and not on and not for submission of the first document. And therefore, the decision of the authority cannot be built at any score. It is arduously submitted that the provision as quoted by the authority that is a manual for procurement of works 2022 convey the laudable intention that the documents sought for by way of a clarification must be relatable to a last date of submission of the application and cannot be interpreted for the purpose of submitting the fresh document, which is dated after the last date of submission of the other. He further submits that the balance sheet appended balancing annexed to the auditor's report are ambiguous and interpret a sense that the same is tailored to make the minister eligible. And therefore, the action of the authority cannot be said to be perverse and or erroneous. You're for the state.
No, successful bidders, 4, 5, and 7.
The senior counsel appearing for the successful bidder adopted the submissions of the the senior counsel appearing for the corporation. And the submissions and other than that, the reparation deserves dismissal at the threshold. The law in relation to a tender are required to be recapitulated before we embark our journey on the peripheral of the submissions advanced by the listener. Before us. The notice inviting tenders are floated containing the various clauses and inviting the offer from the unwilling participants. In order to promote the competition and the best suitable price at the best suitable price for the work. It admits no ambiguity that the clauses embodied in the notice inviting tender contains a character of a contract the moment the offer is made, accepting the proposals. The conditions and on the stipulations contained in the notice inviting tender has to be rigorously accepted And the author is being conscious that it constitutes, it shall constitute a part of the contract. The moment the acceptance to the proposed conditions is conveyed by participating in the table process. After the bench is opened and the successful bidder is declared, in absence of any special agreement entered subsequently, the terms and conditions of the NIT remain operative and binding on the contracting parties. And is an integral part of the contract. There is no fetter on the part of the authority, inviting the debtor to put the conditions in the tender document. And the right to reject the bid on non-fulfillment of any of the terms and conditions are inherent and ingrained into the authority. The scope under the judicial review against the decision of the authority, either in accepting the bid or rejecting, either in accepting or rejecting the bid, is limited. Unless the court finds that decision being tainted with purposely, bias, arbitrariness, and above all, cannot be displayed on the test of reasonability. Within the Vendor's principle. The adherence to the conditions is set upon law in a valid in participation in the tender process. And therefore, the intending bidder must satisfy the conscience of the court, exercising the power of judicial review, that the decision of the authority in rejecting the bill, either at the technical stage or at the technical stage or the financial design, does not meet the basic ingredients of the law as
It is about. It is no longer resented that the suitability and the eligibility of the intending bidder is adjudged at the last date of the submission of an application. And if the documents are required to be filed along with the bid document, it must find its existence as on the last date of the submission of the bid. The decision of the authority in extended the benefit, in extending the time for submission of a fresh document after the last date of the submission is always regarded as an action tinted with a smack of arbitrariness, augmenting the nepotism and the favoritism. In the backdrop of the above, the provisions contained in the manual for procurement of the works 2022 manual for procurement before that section 1.4.5 of the manual. Applied by the authority has to be construed in a pragmatic way. It is evident from the language employed in the said section that at the time of evaluation and the comparison of the bids, if the procuring agency perceived any ambiguity and or discrepancies, may request for clarification within a specified time. With clear stipulation that such clarifications cannot mean any change in price or the substance of a bid, including the specification. Stop. It further conveys a clear message that such information in case of our historical documents, must find its existence before the date for opening of the bid. In order to acquire the confidence that no significant changes have taken place by the passage of time. It is to be kept in mind that the terms and conditions of a contract cannot ordinarily be permitted to be varied unilaterally. The moment the offer and acceptance, the moment the proposal, offer and acceptance are complete, it protects the character of a contract and the signatories of the and the contracting parties shall not be permitted to vary any of the terms and conditions of the contract unilaterally. But the variation may be permissible on the consent of the contracting parties. At the stage of a notice inviting tender, once the bid is submitted, the acceptance of the bid depends upon the fulfillment of the conditions contained there. And in the event any part is provided in the statutory document to operate in a specific field, it has to be construed in a meaningful manner and not pedantically to frustrate the core object and the purpose of inviting the bid. Section 5.4.5 of the Manual of Procurement of the Works 2022. No bestowed power upon the procuring agency to seek clarification, but in view of the express embargo given having contained there, it does not construe as a provision for enlarging the for submission of the documents or fresh documents to be submitted after the last date of submission of an application or the date of the opening of the bid. The clarification as conceived in a orderly sense is something to be clarified on the existing document. And not the submission of the first law. The set clarification, the tenet of the clarificatory letter does not convey a laudable intention as to what is sought to be clarified by the dispenser. But there is no hesitation to pursue such a letter in the background of the facts and the circumstances that the same was intended. Were intended for the purpose of the date given in the auditor's report on the network of the register. In other words, the clarification was sought whether the network as shown in the auditor's report is as on the date as on 31st March 2024 or 31st October 2024. Subsequent auditors report containing the network is a press document, as there cannot be any change in the substance of the bill in terms of the set provisions applied by the authority in rejecting the bill at the technical bid stage. We do not therefore find that moment the letter seeking clarification is issued by the authority, the network submitted by the submitted in the reports of the network indicated in the report submitted by the auditor as of 31st March 2024. It's not a fresh document, but a clarification on the network of the reference as on the same. We thus reject the repetition. We thus do not mind the repetition sense merit the same as your righteousness. So far as the repetition defined by as a social activities and health advancement is concerned, the challenge is basically founded on awarding the marks in terms of is in terms of the terms and conditions incorporated in the section with document in the letter in the notice inviting paper. Clause
6.2.
Clause 6.2 of the notice inviting debtor contain an exhaustive mechanism for evaluating the bid of the intending bidders. By awarding the marks for different specification. According to the senior counsel appearing for the reference, the authority does not exercise its discretion in awarding the marks erratically. One should award the marks the moment the bidder meets the requirement, supported by supposed evidence. The said clause contains the technical evaluation criteria and the eligibility and the suitability is to be adjudicated on the basis of marks divided in several components on the basis of the various criteria, but out of 100 marks. Clause 6.2.2 of the NIT postulates that the qualifying technical score of opening the financial bid is 75 out of 100. Meaning thereby, the intended bidder is secured less than 75 marks out of 100 marks, earmarked on several eventualities, shall be kept outside the zone of participation in the financial bid. It is right to mention that awarding the marks for each category of the specification is within the exclusive domain of the authority. And a uniform method of awarding the same should be adopted. There are certain stipulations which rule out the exercise of discretion by the authority as the same is basically based upon the document to be submitted in support thereof. But there are certain specification and or eventually which confers a discretion upon the authority in awarding the marks. on the basis of several considerations. Admittedly, no, sorry, undeniably, indisputable, undeniably, no, it's not. It appears from the document, because you will not admit that why I'm rephrasing. It admits from the document that is to the counter-affidavit that the petitioner secured 64 marks out of 100 and therefore does not makes it illegible in the financial bill in view of the conditions imposed under clause 6.2.2. It is vociferously submitted by the petitioner that the marks awarded against the 60 marks appearing in serial number 123 of clause 6.2 is arbitrary and smack of nepotism and favoritism. The senior counsel was conscious of the proposition of law that the power of judicial review in regard to the tender or within the limited compass, as the rich court cannot interfere with the decision or the order of the authority, but shall exercise such part on the decision-making process. According to the senior counsel, the manner in which the marks are awarded to the petitioner by the authority is suggestive of perversity and the other factors which renders the decision of the administrative authority liable to be interfered cannot be ruled out. On a meaningful reading of these. The clause 6.2 there is no ambiguity in perceiving that in some cases the marks are to be allotted and the marks are to be awarded on the basis of the fulfillment of such conditions. But it's in others, a discretion is also vested upon the authority. to award the marks to each of the intending bidder, which may fell short of the marks earmarked for such purpose. We find that the authorities have provided a reason of awarding 64 marks which cannot be said to be perverse, irrational, and or unreasonable. We are conscious that the authorities must act reasonably and must provide the reasons before rejecting the bid of any of the intending bidders. Any decision which is bereft of the reasons cannot be said to be a decision in conformity with the law. The interference by the Red Court to a decision which lacks reason is well known, but if the decision is, if the reasons is given in the order passed by the administrative authority, the scope for its interference becomes minimal. Stop. The moment the court finds the decision to be reasonable or rational and take on the assimilation of the facts and the events, the court should be, the Red Court should be slow and circumspect in the interfering with such an order. We find from the documents appended to the counter-affidavit that the authority assigned the reasons in justifying the 64 marks awarded to the petitioner, which cannot be said to be perverse or tainted and snap of arbitrariness. It's it takes us to the another plea taken by the petitioner that awarding 40 marks for presentation is too onerous and may invite the misuse of power and the authority in selecting the suitable figure in terms of the same level. In support of the appropriate contention, the reliance is placed upon the judgment of the Supreme Court in case of State of Assam versus Arvind Bhabha and others.
Para 40, it's a para 40, para 44
Well, 44 is not a.
No, 3940, my lord. 3940. The government's decision has been upheld.
The ethics of in the instant judgment, in the instant report, in the instant decision. Applicated the action of the government or its instrumental is selecting these in in selecting the eligible candidate solely upon solely on the basis of an interview. So, it is not here that if such procedure is adopted, it will populate a sense of the arbitrariness and at times the suitability, the assessment of the suitability may be undermined. There is no quarrel to the proposition as laid down in the above report. Had it been a case that the entire selection is based upon the marks to be awarded in the interview, the position would have been different. In public employment, the selection cannot be founded solely on the basis of an interview. As at times, which cannot be ruled out, the element of arbitrariness is found. And the eligible candidates are arbitrarily kept out of the zone of public employment, which offends a core value of Article 16 of the Constitution. The selection by way of an interview is susceptible to be misused and or abused at the behest of an authority. And therefore, such selection process cannot be said to be in tune with the constitutional ethos and operates ethos. Full stop. A decision is what is decided in the context of the facts and the other factors involved in the same case. A little difference in fact or an additional fact may invite a different decisions, and therefore, in order to cull out the ratio, the court must also consider the facts involved in the same case. In the history case, the entire assessment of the suitability is not built on the basis of our technical presentation, which is amenable to be abused and or misused at the behest of the executive fiat. But several other parameters are also provided, earmarking the definite marks, therefore, and it cannot be said that the ratio of floor laid down in Aurobindo Raha has any manner of application in this. It takes us to another plea taken by the reflector that the decision of the committee was never communicated to the reflector. And therefore, the action is liable to be interfered with in view of the judgment rendered by the division bench of this court. In case of Sikal Logistics Limited versus Mahanandi Coalfield Limited and others. Reported in 2017, Volume 2, ILR, Cutter 102.
Para 9, 10 and 12.
The said judgment is rendered on the basis of the administrative decision by the authority in cancelling the tender process and then issuance of the first tender process without providing any reasons. The deliverance of the court of the reasons is a concomitant of passing an order, and therefore the authority must discharge its duty so assigned in a meaningful manner. It is highlighted that the providing reasons, even in an administrative field, is the reflection of a mind and the considerations behind the decision, and also conveys a clear message to the persons who is affected by the decisions. In such perspective, it was here that non-communication of the decisions raises great suspicion in the action of the authorities. And there is no pressure on the part of the rich court to interfere with the same.
I see.
The history case has a distinguishing facts and the features which renders the judgment of the coordinate bench inapplicable to inapplicable. The authority, while rejecting the bench at the technical stage, recorded the reasons which cannot be termed as perverse or as the act of arbitrariness. The we found that resolution to the proposition of law that the authority must communicate the decisions affecting the rights of the parties and should not sat over the same for a considerable period of time. The communication of the decision not only ensures the fairness and transparency in the administrative field, but also inculcates the sense, but also percolates the reasons to the person to understand the grounds for which for which his offer is rejected. We find that the last date of submission for the said application was fixed on 15th November. What is the date?
Yes, sir. 24.
IP 11.
15 November 24.
15th November 2024. And subsequent thereto, the steps are taken for the evaluation of the suitability of the candidates. Is only inferred that the evaluation is done much after the last date of the submission, on the basis of the fact that one of the participating candidates, that is the sanskar, was issued with the letter seeking clarification. Stop. The documents annexed to the counter-affidavit reveals that the minutes, the meeting of the committee took into consideration all the applications submitted by the intending bidders, including the rate listeners. And the decision was taken. Thereupon, a distinction must be drawn between the act of the authorities who sat over the decision or did not communicate the decision after having passed for a long considerable period of time, and the decision which has been taken in a close proximity of time, and the litigation is ensued, wherein such a disclosure is made in the pleading by way of filing a pleading, by way of filing a pleading. We thus do not find that the plea taken by the requester that the communication, the no communication was made would entail the entire exercise liable to be stopped out. So, the repetition is also discussed.
Item number 1, ARBP 1 of 2025.
Since for appointment of an arbitrator, for your lordship convenience, we have given a short note. Just as a recap, if I can just quickly run through that. That's, my lords, at flag C, page 295 of the PDF version. Hope your lordship got that. The short note would be a PDF 295. Flag C. Arises out of a raising contract. And section 21 notice, all those details have been given there.
Yes.
And we have given, for your lordship's convenience, we have given paras from the counter where they, before the Madras High Court we lost. Here also they are raising the issue of territorial jurisdiction. And in their objection to section 21, they are saying that we have to go in the civil suit which they have filed to cancel the power of attorney. So they are trying to block us from on the ground of territorial jurisdiction, on the ground that these disputes would come under the civil suit. So here, if your lordship wants, I can show that there is one judgment which is a part of a note also, which says that suppose there is one main contract and other contracts also do not have an arbitration clause, then following that umbrella contract principle, it can also be sent to the arbitrator. And the new trend of the Honorable Supreme Court judgments is at the 11th stage, you refer it, the arbitrator can look into this at the 16th stage. So they can have their say at the 16th stage. At that point also, I had raised this earlier. Regarding the tenability of our claims or whether these claims are arbitrable.
These are within the realm of the arbitrator.
My lords. So the new trend of Supreme Court judgments I have given, my lords, including a 5-judge bench judgment, where they say that you leave it to the arbitrator to decide.
Cox and King.
Cox and King. Great.
Lordship, first of all, in the event of an 11-6 application, there are two things that have to be taken into consideration. First being the existence of an arbitration clause, which with regards to the raising contract, I am not finished. Secondly, is the arbitrability of the dispute. Lordship, our entire objection is regarding the arbitrability of the dispute. Considering what they have been saying, Cox and Kings is not applicable in our case. Cox and Kings is regarding a group company. This dispute, which they are claiming, is not regarding the group company.
Follows the chlorochemicals judgment.
Lordship. And Duro Felgura, which exactly talks about this particular aspect. Duro Felgura specifically states that when, which in our note, Lordship, we have also pointed out, on page number 4 of the note, Lordship.
That's a
Email.
This is a draft, I suppose. Note was already earlier also submitted to the Lordship.
For your lordship's convenience, it would be at page 475 of the PDF.
It is for the Lordship's convenience that I've pointed it out. So, paragraph 20, 23 and 52 have been pointed out of Bureau Felgura, Lordship, in which it has specifically been stated where the contracts are separate, where the intention of the parties can be made. Lordship, I'll read the paragraph 52, which we have reproduced. The scope of power of section 11 of the Act is confined only to the examination of existence of arbitration agreement, where there are multiple agreements. Only some contain arbitration clauses. Dispute under non-arbitrable agreement cannot be referred to arbitration. In that regard, Lordship, the raising contract raises no dispute with regards to the parties. The scope of raising contract is very limited to for them to act as a contractor. They will continue the work, which I would contest that they have also failed on that
The
aspect.
only thing is, the bottom line of the entire thing is that whether these contracts, several contracts are separable or inseparable in nature. If they are inseparable and all are intertwined into one, then in that event, this, the judgment of this, even a duro, which you are referring this, talks about that it is arbitrable in nature and to be decided by the arbitrator. Here we have to look into the contracts, whether those are inseparable, they are so intertwined with each other that one cannot seek his independent existence, because if you look at paragraph 2023,
Lordship.
that really talks about the same.
Indeed, Lordship, that's why we have reproduced. We've not done.
So one and foremost thing is that whether what is the nature of the contract,
Very well.
all are really aiming at the raising contract. If they are raising at if they are aiming at the raising contract, which contains an arbitration clause, then why not?
Lordship, I concur. I concur on that very point. But then in that case, there is a concept of a mother agreement. In that regard,
This is what paragraph
Yeah,
20
indeed,
says,
indeed.
that there are 5 separate letters of award, 5 separate contracts, separate subject matters, separate and distinct work, each containing a separate arbitration clause signed by the respective parties to the
Lordship.
The intention of the parties to split up the original package number 4 TD into 5 different packages, each having different works, prima facie indicates the intention of the parties to have the independent contracts. So that's why I asked you, if it is an independent contract,
Lordship, in our
then
case,
that
it is
if it is not, if it is anyhow connected with the main, then sorry, this judgment also does not suggest so.
Lordship, in that regard, I'll very well state that this is an independent contract. Or
Now,
there are
tell
three.
us then what is the nature of the contract and how this is done?
Lordship, the tripartite agreement, which it has been entered into, which they have been referring the dispute is in, categorically states that the very reason why it was entered, because Gayatri was going out, Gayatri mining was going out. They were coming in, and we were the mining leaseholder. They categorically state that 2011, the mining lease would be over, would expire. A renewal process has to be undertaken by them.
So it is in relation to that.
Lordship,
Then,
those are
independence of that particular contract.
Lordship,
What is-
those are just the recitals which state what the facts of the what facts the incoming company should be aware of. There is no scope of work which has been defined.
Whatever you are arguing, you are really infringing upon the merit of their claim. Merit of the claim can only be decided by an arbitrator. We are at least at section 11 stage, we are not entering into the merit.
Lordship, I am not trying to enter into the merit.
Prove otherwise. Why we will enter into this?
Lordship, I am not entering into the merit.
Let him decide.
Let us then go to the notice that has been served upon us. The dispute has to be disclosed to the effect where Lordship is well aware that the dispute which is disclosed itself goes on to become the statement of the claim. In that regard, they have pointed out the dispute in paragraph 4, 5, 6, and 7 of the notice.
I'm suggesting that if they have assigned a particular ground under section 21 notice or at section 21 stage, they cannot include any other dispute at the time of filing the statement of claim.
Lordship, with effect to the 21 notice, that is what
I don't think so. There are.
We have one
The law
great judge.
against that.
He knows it, the recent judgment saying that can be included, subject to limitation.
Lordship,
I'm asking him.
I'm so sorry.
Why I'm putting a question, I know why I'm.
I'm
putting-
sorry.
Lordship, be that as it may, they may be able to expand upon the scope. But what is the end result they are wanting is something which has to reflect in the 21. Section
Only thing
11
is that
application,
moment-
which is
the
moved
moment
here.
They say that there is a dispute that has arisen. And they have indicated in a very concise manner. It does not rule out that all the disputes cannot be raised at the time of a statement of claim.
Lordship, what
Only thing is veracity, genuinity, authenticity of the dispute, merit of the dispute is not within the domain of the High Court under Section 11.
I concur, Lordship, but in that
There-
regard,
They
at
have-
least a
we are
dispute has to
referring-
be.
Referring the dispute to arbitration does not mean a foreclosure of your right to defend.
Lordship, in that
We are
regard,
not going to say anything on the dispute. We will simply say a dispute has arisen.
Lordship,
Whether it's a genuine, not a genuine. We can go into the validity of the arbitration agreement, no doubt about it.
very well.
That from a 5-judge decision of the Supreme Court SBP Limited versus Patel Engineering, we can definitely look into for the such limited purposes.
Lordship.
Not beyond.
But in that regard also, Lordship, Section 21 notice has to highlight that there is a dispute. What we have been claiming, there is no dispute.
That is, you perceive, they perceive that there is a
Lordship,
dispute.
in that regard,
What
the
is the-
scope of raising contract has been limited to the
What has to be,
contract.
the dispute means what? Somebody's action is perceived not in consonance with the terms of the contract.
Lordship.
And other side says, no, it is not so. I mean, within the contract.
Lordship, in that
That's a dispute. They are not at item on a particular score.
Lordship, in that regard, we perceived a dispute where we had filed an FIR against the power of attorney holder. We had perceived another dispute against which we had
That will take its own course.
very well,
Not
Lordship.
let the arbitrator decide if there are overlapping issues.
Lordship.
Some of the issues are coming within the domain, some outside. It's the arbitrator who can decide. No difficult.
Lordship, in that regard also,
Under section 716, he can.
Lordship, if your Lordship would refer to paragraph number 5 of that notice, what they have been claiming is us halting our legal rights which have been granted to us. In that regard, a arbitrator or any other entity cannot stop me from exercising the rights which have been granted to me, which are
That is
filing
what
an
you
FIR.
argue before the arbitrator that you cannot pass any order, divorce this. Arbitrator will decide and say, yes, we are incompetent, we are not conferred power to do so. I think what I'm saying, a distinction has to be made at the section 11 stage and the arbitration stage.
Lordship, in that regard, I'll again vehemently submit that whatever they have been claiming is not a dispute per se. That is not how the dispute is supposed to be taken into consideration. There is no arbitrability of this particular contract, and both these contracts are separable, cannot be taken into raising contract cannot be taken into consideration as the mother agreement. At Lordship, these objection may be recorded in that regard.
Obviously, what do you think? I can say that I do not shy away from recording whatever the submissions are.
About
And I think it is my duty, solemn duty to do so.
Lordship.
It's good. I may not agree on a proposition of law with you. That's the another aspect. Is a very healthy interactions and the communication. Convince me that my notion is wrong. I am ready to accept. I have no difficulty. Convince me that I am wrong on a proposition of law.
If I may take another attempt at it.
Yes, where is the? Just show me the section 21 notice. Show me the raising contract and.
The raising contract in the PDF version, your lordship may kindly see page number 335 is the need copy.
Physical. Which one?
If, we have given a neat type copy at page 18 of page 18, annexure 1.
He is the party of the first one, owner.
My
You are
lordship,
the
Prabhu, the petitioner is
Lordship, I am
You are the owner.
Prabhu Dayal.
Owner.
owner
Yes,
of the
Lordship,
matter.
Lordship.
And you are the agent.
And the agent. The statutory agent under 8 capital A of the Metalliferous Act. The agent under the Metalliferous Mines Regulations, 1961. 8 capital A of that. Okay.
Yes, and now, what is the other contract? What dispute, where is section 21?
21
Where
is
is tripartite agreement?
that is another agreement where the previous agent was removed and we came in. So that is between
This agreement, basic contract was entered into on 18 June 2012.
Both agreements on the same date, Lordship.
There was a raising with the earlier.
But the earlier agent. So earlier agent went away.
It was a Tantra oxide.
Lordship, earlier was Gayatri Mining as per the tripartite.
Tantra, you have entered agreement, that is of 2009, I find.
Lordship, that is the agreement between me and Gayatri Mining, which was entered into in 2000.
Mine from Tantra. Tantra is.
Tantra is the name of the mine, the village. in which-
Gayatri is the agent.
Previous agent.
Lordship, tripartite agreement is at page 47.
That agreement for sale to the Tantra. What is this joint venture?
That is also with the previous agents.
Tripartite is 18 March 2010.
Tripartite agreement annexure 3 is between the owner, that is Prabhudayal Agarwal, Gayatri, the previous agent, and the present petitioner, Anand Granites. These facts your lordship would find at page 47 and 48.
Now, where is the dispute? These are the two contracts. Or there were multiple contracts.
There were multiple contracts. Then in addition to this,
There was a power attorney.
there was a power of attorney,
Irrevocable.
irrevocable power of attorney, annexure 4, page 56.
Then what is the other?
Then there was an affidavit to transfer the mines that your lordship would find at page 70. Annexure 5.
Where is the letter?
In Annexure 8 is the 21 notice.
Where is the?
Annexure 8, page 86. That's further followed up by another letter at Annexure 10, page 91.
Which one?
The 11, section 21 notice is further followed up by another letter at Annexure 10, page 91.
Limited. Whichever was something else. Just to yes.
Lordship, in that regard, the entire exercise with which this has happened is
Please
that there is no
consider
dispute in
these
the
contracts are separable or inseparable. Let us
It's all vis-a-vis single mine. All these mines.
Lordship, in that
Tripartite agreement, I have seen the racing contract agreement.
Mines.
Tripartite definitely does not contain any arbitration.
Mine.
The racing contract contain an arbitration.
Mines.
First thing is that whether tripartite can be said to be an independent contract, he holds the racing contract, or it is something which should be connected with the racing contract. If it is connected with the racing contract and does not have the independent existence, then in that event, the law is very clear. He is also relying on a same judgment which goes against him. If it is separable,
Separate.
independent, no different.
Lordship, in that regard, is it the opinion of the opposite side and of the court that there are no disputes as per the raising
There
contract?
cannot be any opinion expressed by the court.
Of the petitioner side. My apologies, I below that
And
statement.
signed by the judge. All are mere tentative observation in pursuit of understanding the reality.
Lordship, in that regard only, I was asking the petitioner side that whether they concur that there are no objections in the raising contract and all the objections that they are referring to are.
Why you wanted a witness to say something in these kind of things? They are not supposed to answer the queries. They have come up with their pleadings, you have come up with your pleadings. You have to decide on the basis of the law.
Very
I'll take care of. I will take care of the obligation.
Item 2.
Dr. Square Section 6, Section 15(2). And also the Arbitration Act of Permanent Arbitration, Substitute Arbitration. And in fact, the learned friend was absent from the previous occasion. He has come, my lord. He is I'm putting respondent 2. That's 2 with the main respondent. And
With your first respondent.
I am referring to opposite that number 1.
When you say substitution.
May I suggest one thing once? Retired Justice Mr. D.P. Chaudhary may be appointed. On the pleadings, everything is complete. Everything is complete. Yes, sir.
If you parties agrees, there
Yes,
is
sir.
flexibility. There are no objection. Yes.
That's right. In fact, there is similar order also, the court that bench, where the substitution arbitration appointed. Because of the forum was lost on pending since 20 years before the state arbitration tribunal is not functioning now. That's the reason that I've also given an order for us. That due to the non-functioning of that arbitration tribunal, state administration tribunal, that's why we sought for this.
Where from this concept of state arbitration tribunal comes?
There was, my lord,
Where is,
20 years.
from where it comes? 323B or Article 323A?
There.
From where this notion?
The state, when the state government is
I'm
involved.
just asking that there must be a power, eminent power that should be conferred upon the state to constitute a state arbitration tribunal. I am just trying to understand. I don't know whether under Article 323A or 323B. I do not know. Can they?
Section 85, I have, in fact, paragraph 3 of my petition, I have, that respondent one is statutory body.
No, under
Section,
clause. Where is the statutory body? Under what statute they have?
the government government party responsible executed by the tribunal as per the saving clause, section 85 of the Arbitration and Conciliation Act 1996. After repeal of the Arbitration Act
I'm
1940.
just asking that what concept, under what provision is a state arbitration tribunal is constituted?
Where state is a party, there was, that's why there's been
Where from?
some clause that, as per the section, clause 85 of Arbitration and Conciliation Act 1996, after repeal of Arbitration Act 1940, minus.
Which provision?
85 minus 85. Repeal and savings.
Yes. No, where is the power to constitute a state arbitration tribunal? I'm just asking. You have made the respondent number one a party. What is the source of its existence? Under what law?
Provisional set enactment shall apply in relation to arbitral proceedings which commenced before the act came into force unless otherwise agreed by the parties, but this act shall apply in relation to arbitral proceedings which commenced on or after this act comes into force.
Where?
The section 85, not reading such repeal 2, subsection 2 minus.
No.
2.
No, please, read.
The provisions of the said enactments shall apply in relation to arbitral proceedings which commenced before the act came into force unless otherwise agreed by the parties. By this act shall apply in relation to arbitral proceedings which commenced on or after this act comes into force. All rules made and notifications published under the said enactment shall, to extent to which they are not repugnant to this act, be deemed respectively to have.
I understand.
Malice.
I'm conscious of the
Malice.
repeal and saving clause. There is no
Malice.
difficulty.
Malice.
Followed from section 6 of the General Clauses Act. No
Malice.
problem.
Malice.
No problem. I am saying that from where this concept of state arbitration tribunal comes.
But there is a rule that is called Odisha Arbitration Tribunal Rule 1979.
That's an administrative tribunal rules, sir.
Yes, something. That is
Arbitration.
That is under Article 323A. I am conscious.
Malice.
State can enact, but I am not aware state arbitration tribunal can be established. I am really seeking that. From where this concept comes. From where this concept comes.
Not functioning up.
There are only one constitutional provision which talks about the constitution of the tribunal and the powers of the state to constitute a tribunal. That is Article 323, capital A and 323, capital B. But it does not really talks about any powers of the state government to make an arbitration tribunal. There can be an industrial labor tribunal, there is no difficulty. But arbitration tribunal justice.
No, it's not functioning.
The very core object of the arbitration agreement is frustrated when you constitute the tribunal. It's a party-centric law where the parties have been given a freedom to choose the forum for resolution of their dispute. If they decided to get their dispute resolved through a particular arbitrator, why not? Arbitration tribunal will go and take. Failure, under section 11, failure to agree on the name of the arbitrator, the court can. So that means that if they both agree, then why arbitral tribunal? I do not know, tell me. When you are relying on this.
No, I want the substitution. That's one.
Are you still in existence, sir?
Only one technical member function.
How you are constituted?
Well, constituted as per the section 4 of rule 4 of Orissa Arbitration Tribunal. But
Can I get it that tribunal rule,
Orissa Administrative
Arbitration rules
Arbitration Tribunal Rule 1979.
that was under 1940 Act. That was under 1940 Act. But there is no power given. It's only repeal and saving clause is the continuance of the proceeding which is started before coming in force of this act will be allowed to continue as if this act has not. What is this rule? Seven. Source of power of this rules. Because change the rules, nobody knows. It's the 1940, you see. Not also under Article 162. Application. To what? It's to appoint to substitute an arbitrator for adjudication of the claim made before the earlier arbitrator. Who was earlier appointed as arbitrator?
State arbitration tribunal, arbitration tribunal members.
No.
The names are not.
The dispute was, where is that? The dispute was referred and being adjudicated by the Orissa Arbitration Tribunal. About the respondent number 1.
State and.
Here. But final adjudication could not be made as the same become unfunctional because of the quorum non judice. A lack of code, because of the lack of code. The proceeding remains in abeyance for a considerable period of time. And the parties, and the petitioner has approached this court invoking section 11. Read with section 14 and 15 of the Arbitration and Conciliation Act 1996 for substitution of an arbitrator to adjudicate the claim. The opposite party, number 2, being one of the contracting parties to the agreement, to the arbitration agreement, conveys his intention that he has no objection if the substituted arbitrator adjudicates the claim of the respective parties, which is pending for a pretty long time. Section 15 of the Act contains the exhaustive provisions relating to the termination of the mandate and the substitution of an arbitrator, provided the contingencies stipulated therein are eminently pleaded and presented in the case. Section 14 for the 14 is relatable to a termination of a mandate of an arbitrator and the substitution by another arbitrator if the arbitrator becomes de jure or de facto unable to perform his functions, or for other reasons fails to act without undue delay, or he withdraws from his office, or the parties agree to terminate such mandate. Admittedly, in the history case, the matter was referred to a statutory tribunal constituted in the state to be for adjudication of the arbitral disputes by the members to be appointed by the state government. But by passage of time, such arbitral the tribunal becomes functionless as the members are not timely appointed, thereby impeding the adjudication of the arbitral dispute. Within a time-bound manner. The object underlying the incorporation of the Arbitration and Conciliation Act 1996 is founded upon the ancestral principle ancestral, the model internationally recognized and being the ratifying signatory at the UN Charter. The said act was, the Act of 1996 was enacted with an avowed object of not only bringing uniformity in a uniformity in conducting the arbitration at the international level, but also but also to make the foreign arbitration, foreign awards enforceable within the country. The primary object of the said act can be envisioned that the composition of the arbitral tribunal is a party centric. And if the parties have chosen to resolve their disputes through an arbitral mechanism, the primacy should be given to the mandate of the parties. Be that as it may, we find, be that as may, I find, and this court finds that because of non-appointment of the members in the arbitral tribunal, the proceedings are kept at halt, frustrating the core value of the said act. The parties to the contract, that is the petitioner and or respondent number 2, have agreed the substitution of an arbitration and uniformly agreed to the name of arbitrator. Both the councils agreed to appoint Mr.
Justice DP Chaudhary.
Justice DP Chaudhary, retired,
Doctor
to act as a substituted arbitrator. Since the parties have agreed to the name of the said substituted arbitrator, he is appointed as the sole arbitrator to determine the disputes. Stop. The arbitral tribunal is directed to transmit all the records to the substituted arbitrator within 15 days from the date of the communication of this order. The substituted arbitrator shall proceed with the arbitral proceeding, with the arbitral proceedings from the stage at which the same is left because of the non-functioning of the arbitral tribunal, and shall publish the award within the statutory period provided in the said statute. The remuneration of the arbitrator shall be as per court schedule. What freedom is given to you? The fee of the arbitrator
As per the fourth schedule, or you wanted the
No, no,
freedom?
Questions.
As per the fourth schedule of we say that to be shared equally by the partners. What more?
What was the problem?
But this concept is unknown.
See.
I do not know the reason behind it, but very.
Yes.
That's I'm surprised. I will not say shocked, but I'm surprised.
When state government is involved, that's what they have.
It's not. Under what
Why not?
authority the state government can? The authority must emanate from the constitution or from the, I think, 7th schedule. It is not within the state list. How can a state make a law? It cannot be. And the state has not made the law. It's by, anyhow, I'm coming and sitting in a division bench after 5 minutes.
Fresh admission item number 2.
When I challenge you, opening up a new IMFL off shop 40 meters away from my shop, my lord. The petitioner is a licensee of a IMFL off shop at the barrack through of Berhampur town.
Live and let live. Live and let live.
You can have a glance to the annexure 2. Annexure 2, my lord. The opposite party number 5 have been settled with the auction of the SBI main bench of IMFL offshore by the annexure 2. That is the this is auction notice, my lord.
What? It is in a SBI main branch.
Main branch. Chowk Berhampur.
In the SBI main branch.
My lord.
You're talking about.
Oh, Chowk, my lord. SBI main branch Chowk. Can you turn to my lord? Page 15 of that notice are the paragraph with R. The holder of the license shall open the shop in the stipulated locality within 15 days from issue of license. But he has not opened in the locality, he has opened in another.
Why you are bothering?
They are not doing my lord. We have,
Let them take a this, what to do. Why you are bothering?
I have submitted representation, they are sitting over my lord. All the locality people and other have submitted under Annexure 5 the.
What you are taking a decision and hearing.
Documents come for the first time.
When this was served upon you.
14.5, but your lordship, until and unless we take a
So
notice.
I think this is the case where I should issue some directions.
Your lordship, what is?
To my brother agreed that this is a recurring feature so far as the litigation against the government is concerned. That on the first day of the motion, the automatic adjournment is sought for lack of adequate instruction. So all the government officials are directed to issue immediately the instructions to the respective councils within 3 days from the date
Your
of.
lordship, what the problem here is that.
We are issuing
Your
mandate.
lordship, the problem here is that these briefs stand in the LLMS, your lordship. But what happens is that in the LMS, it is not specific to any department or any district. So your lordship, they do.
I have no idea.
Perhaps you have not been praised properly.
No, your lordship.
See, all the departments, they are stated in the LMS and they are sent simultaneously.
Yes, your lordship. But from, it goes on a bulk, your lordship. So from there, this read pertains to Balesore district, this read and excise.
So look to have nodal officers there to segregate. Should you sit on that?
As many briefs as the High Court has, that many briefs mostly we have also your lordship become very difficult.
Function.
So once we get a notice to seek instructions becomes easier, your lordship.
Sir, partner, to facilitate the functioning of the court, how administratively efficiently you will perform. That is for your office to decide or take up the call. How can you put the blame on
I think the mechanism can be adopted by the state. There is a software by the name of Sarthak. In the state from where I come. That particular software, whenever any petition is filed against the government, immediately it has to be uploaded on the software. And it goes to a respective department immediately. Automatically it goes. And those are filtered. And within 48 hours, the instruction has to be used. So the instruction immediately, sometimes not 48 hours, it comes in 76 hours or so. But at least it does not really process more than a week, never comes. It never crosses a week. I think you have a model, you have best IT brains. You can make those formulas in your software.
Especially Advocate General, your lordship.
software is there.
Absolutely,
But
that's why-
what she says, it is bulk.
What bulk?
So,
What bulk?
It doesn't specify a department and goes to.
This can be easily done, that is what I'm saying.
I've spoken to the Advocate General, your lordship, and he said that he's going to discuss.
Even for
On the last occasion, your
I tell you, there are many departments in the government, one relation to telecommunication or one is education, one. That education is also bifurcated, primary, pre-primary, secondary, higher secondary, then the universities, the colleges and all, everything, the department, it goes. And it goes to a respective district. Suppose it is from, say, the Bhadrak. It goes to that particular, the Bhadrak. Respective.
I will discuss with the
And
Advocate.
there cannot be any bulk.
constantly it will go to all the.
All, it goes, it can't be a bulk. 4, 5, 10, 15 maximum per day. And what is the population here? Just tell me. Very less. Why there will be so much of accumulation of the litigation? If everything is streamlined, it can be sorted out.
Just on the first step, you can be able to say what is the state of consideration of representation. Many cases.
This is what we really wanted. That's why I'm saying it can be disposed of here and now.
I will speak to the Advocate General, your lordship, and even where we can have a meeting with the LMS provider.
They develop it.
There is no difficulty. You can develop the software. You can do. There is no problem.
I will let.
Technology has advanced to the.
Little bit modification is required in the LMS, nothing more.
You have a dedicated IT cell.
Yes, your lordship.
So, instruction. It's not.
Item number 3.
Hearing. But he must be here as well. Possible.
3 and 4 both.
What is the name of the?
S.E. Mohanty.
That was filed by the sub-function, your lordship. The last location, this is a sub-function of
In the absence of the advocate, you can't, so then can you inform this,
S.D.
Hansu Bhushan, Monty? And he's hearing from both the bank. This one.
John, this letter from.
We can dismiss it for default, no difficult. But they have filed the withdrawal memo. So can you bring him for 1 second?
Number.
Anybody knows him?
Everybody knows.
The telephone number.
No, he is regular practitioners.
It's called the.
Item number 5.
It's that 180 ml. IMFL ounce of similar order maybe.
180.
180.
180.
Yes.
Item number 6.
May be the lawsuit last procurement directed to the government council. I will be tendering paper, downloading from the website.
I'm extremely sorry, Your Lordship, only a one copy in Sarah today itself, Your Lordship. We also have the paragraph coming to Your Lordship. Your Lordship may give us some time, we will file a counter-affidavit. The instruction says that they had given the three institutes of tender that they had done work. And if it is divided into civil and electrical, because the electrical work doesn't come to 40% that they require, represent the 40% of the tender work, Your Lordship. The estimate it doesn't meet, so that's why it was rejected, Your Lordship.
For the different purpose, when they ask you or part of standard document.
Yes.
Actually, that was there.
My instruction is concerned, he has guided their best methods.
That's why we wanted their reaction to.
As per clause 15, Your Lordship, we should have the experience of at least 40% of the estimated tender work.
He says that for coming in electronic form, I can't now download. So we say that you have an access, you can download. If all those documents were included at the time of filing or submitting the
Yes, Your
petition.
Lordship, I have also flag marks.
Instructions must be there, with regard to order fast.
Your Lordship, I have flag marks here, the tender evaluation committee's remarks. Those documents were there, so that is why they have already put in their remarks here, Your Lordship. Why it was rejected, Your Lordship. We had that.
They say that
Yes, they say that for the estimated of requisite is 40% of.
This first paragraph. More particularly, this certificate and this is several of the instant receipt. Whether that document form part of final document or.
This is what they have decided, he has not fulfilled that criteria, those were part of the tender documents, Your Lordship. Whatever he has.
7 is the document they are relying was part of the tender document.
Because, Your Lordship, that I have to call the officers, Your Lordship, we have received it today. We have received it today, Your Lordship, what I can make out.
When this order was passed on 20th of June, you must have communicated this order to
Yes,
your
Your
office.
Lordship, yes. Your Lordship.
Paragraph 1 was very clear, that order. What we really wanted, the answer would be only in 2 words, yes or no.
He has given that he has given submitted an experience certificate for 3 numbers of works for an amount of rupees 47,65,000.
He says that one of the conditions was that he must have an experience of doing the work.
Yes, Your Lordship.
He says that the authority has rejected because he could not show that he has an experience.
Yes, Your Lordship.
He submitted the document, so we
Yes.
wanted whether this document was included or subsequently he has gathered and for the purpose of writ petition, he has come up.
Subsequently, because it is not been
Okay.
placed before the tender evaluation committee, Your Lordship.
If this is what we wanted, whether he submitted or not, if he has not submitted, he has no case at all.
And they had also, after the rejection of the tender,
Sir, after affecting on the instructed you. That's children written in your otherwise
Your Lordship, this brief was allotted to Mr. Devashish Tripathi AG. But since he is on a death reference matter, Your Lordship, at 2 p.m. it was fixed. He requested me to.
Then you are appearing without reading the contents.
No, Your Lordship, I have read the tender documents, Your Lordship. What has happened is that when it was rejected, it was said that on a particular day, they can, whatever grievances they have, they can upload it on the website through an email.
Where is the order of rejection of your bid?
Lordship, Annexure 1.
If I may be allowed, Your Lordship.
Annexure 1, Your Lordship.
Annexure?
1, page 16. Item number 5.
Rejected technical.
Yes. What has happened?
Clause 11A
Yes.
of detailed tender call notice.
Which one?
Will not remark column. Not fulfill the criteria as per tender call, detailed tender call notice. Well,
Not fulfilling criteria as per DPC or 11A. Where is the?
69. Page 69. Annexure 7. 69.
Yes, 69, 11A means experience. The bidder should have the following experience in the nature of the work as per clause 15 of the bid information.
No.
For these three, during the last 5 years, whose value should not be less than 40% of the estimated cost put together.
So his value is less than 40%. Because the tender works that he has given, that has got civil and electrical. When the electrical work is segregated from the civil work, that is not coming to 40% of the estimated tender. That is why it was rejected. And in the rejection order, when it was rejected, they were all intimated that you can give whatever grievances you have, whatever queries you have, you can approach us through an email and also be present on Your Lordship on 3/6/2025 at 5 p.m. In the cover. Neither they were present nor any email was received by the authorities, Your Lordship.
It is a composite contract.
Yes.
Then the composite contract has to be considered in that line.
Your Lordship, it was for
Installation or the drilling of the medium deep tube well. Construction of a pump chamber, laying of the pipeline, so everything is allied to that.
basically it is a work of a substation, Your Lordship, and it also deals with high voltage lines, Your Lordship.
No, this is what he has also done it.
Yes, Your Lordship. But actually it's more of an electrical tender. These are all subsequent. So when you have segregated the electrical part, it is coming to Your Lordship. They have given us in the instructions that only 5,20,521. Another tendered work is 5,10,653. Another tender is 8,37,807. Only such minimum quantity of work pertains to the electrical part, Your Lordship. The rest
How
was
can
civil.
they segregate a composite?
Because, Your Lordship, this is a developed.
He has given a certificate which is composite one.
Yes, Your Lordship. But this tender and the work relates to a electric substation with high voltage electrical line for the change, Your Lordship. So that the experience in the electrical sector is very much important. And he has done negligible 5 lakhs, 6 lakhs, 8 lakhs
yes.
of electrical work.
No, the certificate is,
Major part is civil, Your Lordship.
how can you say
They
How
have,
can you segregate it when the authority are not segregated? Can you say that out of say 1,000 lakh, this much of lakh will be civil when you don't know, you are not the authority?
Your Lordship, they must have, Your Lordship, because that is how this entire evaluation committee has decided.
Nothing.
Let me file a reply, Your Lordship.
Okay. Who is that? Who is the cherry?
Yes, Your Lordship.
Boy or a person?
No, Your Lordship.
No?
They were around 10, around 10 bidders, Your Lordship.
No, 9 bidders.
9 bidders, Your Lordship.
Out of 9, 5 has been rejected.
5 have been rejected.
6 has been rejected.
Six has been qualified, Your Lordship. 3 has been disqualified in the technical evaluation committee, Your Lordship. 6 have qualified, 3 have disqualified, Your Lordship.
This is really a 90 lakhs lot. How can this segregate which major portion is?
You have any material, report, Tandoon committee?
Regarding this, like page 77, page 37. You don't have to go. So, you know, we can't have, because it's a composite problem. It's a composite problem. It's not really, that's it. Madam, this is not.
I have to see. This is, Your Lordship may see, this is how they have evaluated, this is the tender evaluation committees. This page and the next page, Your Lordship, they have seen all the way.
What you are submitting, I do not find from the document.
Your Lordship, it is given in our instructions, Your Lordship.
Your authorities have not said anything.
Yes, Your Lordship, on the parawise coming, the first page, Your Lordship, it has been written. The first page.
When you were evaluating, the committee was evaluating, it did not say so anything. Did not say so.
11A, Your Lordship, they have, given in detail in the first page, Your Lordship, last paragraph, Your Lordship.
That's all.
The first page, last paragraph, Your Lordship. First page.
On the last page, they after extracting the details of each and every participant. On the last page, they have simply said you are not qualified, level A.
Yes, Your Lordship. They've given in the parawise comments a breakup, Your Lordship. That I have to ascertain, Your Lordship. That I have to ascertain, Your Lordship, whether it was broken up like this before the technical committee or it is there in the file, Your Lordship.
The actual answer which we asked for is not given by your authority. The actual answer which we wanted was whether this part, the page 37, that certificate which they have appended, was there along with the document, tender document. Because we find certain, I think, suspicion whether it forms part of the tender document or not. There was a suspicion which was raised in our mind. No answer is coming. Now when you say that yes, this document was there, then your consideration in rejecting is wrong. Then it has to go.
Lordship, may keep
But you
it
can't.
next week, Your Lordship, I will seek instruction.
Nothing.
On Friday.
Again, another person will come.
No, Your Lordship, I
The
will
brief
come.
will be entrusted to somebody else.
Your Lordship,
You may be engaged in some other court. No, may not be in a death reference, but some other court.
can be also in a death reference, but Your Lordship,
You don't
death
know.
reference is carried out every day, Your Lordship, till it get over. So he may be excused, Your Lordship. I will come with the answers, Your Lordship. We keep it to 4th, Your Lordship. We keep it to 4th.
Total document which he has uploaded. Copy of this document which he has uploaded. Entire document. Where is?
4th, Your Lordship, I will come and I will reply, Your Lordship. This has come in the morning today and this is all I have with me, Your Lordship.
July. 8th July.
It is defined, the technical bid has already been, financial bid has been opened. In the technical bid, it has been stated that the financial bid has been opened.
Any work contract is issued,
No, Milord. No, no. No, Milord.
any work contract is issued.
They have written it has not been, your worship, they have not written.
Page 17.
Only thing they've written is that on that very day, they were intimated that any grievance you have, you can put it on an email and also be present such and such time for the opening of financial bills. Even the disqualified bidder.
We got instructions clear in you. Ask for one. There in hand, and that's it. That has separate.
It's the route sheet. Attach separate copy, your lordship.
Yes. The dispute was around the submission of a reciprocal document relating to the experience of working, the signal nature of the work in any department, which should exceed the 40% of the total value of the tender. Having not submitted by the license. The petitioner relied upon the certificate issued by the community authority, which includes the conditions enshrined under clause 11 within bracket E of the said tender. Said notice inviting tender. Since his suspicion was raised whether the said document annexed in the requisition forms integral part of the bid submitted by the petitioner before the authority. The direction was passed on 28th June 2025 for the state to apprise the court in this regard. Ms. Patnaik, the additional government advocates, she has received the instruction from the authority, which indicates that the petitioner does not fulfill the criteria as well. we did not find any specific answer has been given whether the said certificate appearing in page 7 of the petition was submitted along with the bid document. And therefore, we probably see proceeds on the basis of the fact that it forms an integral part of the application for application submitted in pursuance of the said notice invited. So the rejection was primarily founded upon non-submission of the certificate as required in the clause 11 within bracket A of the NIT. And therefore, we find a prima facie case having made out on the basis of the document annexed at page 37 of the instant petition. We are given to understand that the tender has not been finally concluded as the financial bid is open. But the work contract has not been issued. We therefore restrain the respondent from proceeding any further on the basis of the DTC order. DTC till the next date of this day.
Right. Item number 7.
Please, members.
This financial bid to be quashed. Financial bid to be quashed.
We brought in an amendment, your lordship may kindly appreciate, the work order was produced before your lordship on the last day. The work order spells out that the order will be implemented from tomorrow. That is why your lordship has called to, please to call the matter to. The issue is, my lord, the issue is very simple. It hinges around one document. I'll tell your lordship what is the requirement and what is the document finding. If I succeed on that document. And if I don't succeed, I'll also not succeed on the document, subject to your lordship's acceptance or otherwise. Your lordship may kindly come to page 18. Annexure 1. Annexure 1. This is the, my lord, the specific terms of the tender. Percentage rate double.
Yes.
Percentage rate double cover tender, technical bid and cover 2 financial bid through online or invited from intended bidder, trading firms or reputed agencies firms in association with their dealers, parties having
Maintenance of the acquiring.
parties having desired experience as mentioned in the detailed tender call notice for execution of the work. Now, I'll take your lordship to page, 21. That is the detailed tender call notice. Page 21. It starts like this, since this is the special nature of work, criteria have been fixed as follows. 1. The bidder should have successfully
Similar project of aquarium, a government or a central government under
successfully completed.
Correct. One.
Right. Government, either state or central government, undertaking.
Turnover should be 50 lakhs and above.
All that.
Last 3 years.
We are on the first. Where the others we are not concerned. We are only concerned about the first condition. That is the document.
Successfully completed this similar nature of work.
And then page 123 reiterates the same position. Page 123. Sorry, page 23 reiterates the same position.
Yes.
Bidder should have successfully completed at least one similar project of aquarium in any government,
state or central government undertaking organization during the last 10 financial years, completion certificate should be annexed. Now, as against this, my lords, your lordship may kindly, the selected bidder has annexed this document. Page 127. Is the completion. This is a completion certificate. Your lordship got the page 127. 127. That is annexure. Part of annexure, my lords. Part of annexure 3. Because these documents were available for everybody's scrutiny, my lords. This has been issued by one Vanya Landscaping and Horticultural Solutions Private Limited. It's a private company. Now, completion certificate on 24/8/2023. This is to certify that Aquascaping MG Road, Raipur has successfully completed the public fish aquarium work order number so and so at Energy Education Park, Keda. My lords, Bilaspur. So this is, my lords, a certificate not directly of any, not directly. My lord, it is been issued, it's a subcontract. Basically, it's a subcontract. Now, this genre of contractors do not qualify, is my specific submission, my lords, before your lordship, under the detailed tender call notice. Now, your lordship will see page 125. Now, he has cited several 15 numbers of my lord's works purportedly where he has done, but no documents have been annexed, save and accepting for the first work. And that too, that is not directly by CREDA. It is by somebody, Vanya, who got the work from CREDA. Now, this man is a subcontractor. Now, clause 1 is that, my lords, of the detailed tender call notice clearly does not include this, my lords, genre of contractors, private experience. It's not acceptable. And the bidders should have successfully completed at least one similar aquarium project in any government, state or central government undertaking. Copy of the completion certificate, what could be enclosed. So if Vanya would have, my lords, my submission is if Vanya would have completed the work.
You are already through now, or you have been?
No, I'm L2. I'm just L2, just above. I'm L2.
So,
and
if you can remove a curtain before you do,
my lord,
you will make an entry.
naturally, my lord, I can match his rate, whatever your lordship, in cases if they want, the government wants, I can match at that rate also. So therefore, in absence of that document, if it doesn't,
I got your point. That's the only point.
that's the point, and our High Court has already decided an issue.
No, that's the only point.
That's the only one. That's the only point.
Clarify. And the successful,
My-
you also may see page 19.
We want to hear the.
Yes, but that's their document only, the document which is on record filed by them. Page 19 of the writ petition, before the detailed tender call notice, the schedule is given of the general terms and conditions. If your lordships can just have a glance, 2 pages, I'll just show your lordships, page 19 of the writ petition.
90 or
19 minutes. They showed about 21, where the detailed tender call notice starts. Prior to that,
Yes.
the general terms and conditions, clause 4, eligibility criteria.
Yeah.
Your lordships may see, come to point C. Proof of contracts related to maintenance of aquariums in government, public and private sector undertakings, along with duly filled annexure C. Because the earlier years, it was only confined to central government and state government. This year, this was not inserted. And if your lordships would come to page 33, where the checklist is given. These 2 documents, my lord, I will show because it has to be read in entirety. Your lordships may come to page 33. The checklist.
Yes.
Clause 3. Yes, so it is not that I'm automatically, because of that clause, I'm ousted. They have mentioned in there, but maybe in the DT chain, it has not been mentioned, but in the first general term conditions, schedule 1, it is there. And then in the checklist also it is there. So on that basis, my experience was accepted and I have been selected and the work order has been issued.
You are maintaining the aquarium.
It is a purely aquarium maintenance work.
Not started.
From
You
tomorrow, it will
start
start
tomorrow.
from tomorrow, 1/7,
Start from tomorrow.
as per the work order.
That is the reason your lordship called it today, so that your lordship will decide the issue, one way or the other. Now my lords, page 18 specifically refers to, my lord, the detailed tender call notice. Page 18, the requirement specific.
Understand, what we have to do about the general terms and conditions which is there.
Man,
The checklist is there. If
man.
there is an omission somewhere here, hither and thither,
Man,
does it invalidate?
my
This.
submission,
So
my
it
submission,
becomes really not a fishing issue, but a fishy issue.
my submission to that, to this, my lord, would be, and my submission is that the tender is to be, the detailed, invitation should be read like this. Parties having desired experience as mentioned in the detailed tender call notice. This does not talk of the general terms and conditions.
It is one of the integral parts
Malus,
of the
one.
technical notice.
One,
Sir, you know law better than anybody. When a general terms and conditions, it is
it is
already
there.
included.
My submission would be, my lord, having a private document, filing a private document may not.
An experience in a government organization, if you work
My lord,
only,
my lord.
that does not mean you have a more experience than you have worked in a
No, here, my lord, the
Okay.
requirement,
responsibility becomes more in a private sector than the
my lord, here the requirement is,
requirement that the general and the why the checklist
Man.
is very important. If you have not filled up the checklist
my
or
lord,
erroneously filled up the checklist,
Man.
you will bid the
my lord, the requirement is that the consideration will be based on the completion of the government one. Eligibility.
is what is there, then
Man.
if there are discrepancies, one stage and second stage or a third stage,
Man.
then what is required to be done?
But how?
How the provisions have to be
Requirement,
applied.
requirement is this, your lordship may again come to page 21. Since this is a special nature of work, this doesn't normally come out. This line is not normally there.
Yes,
Since this is a special nature of work,
correct.
criteria have been fixed as follows. This does not make for any, my lords, any other interpretation. Bidders should have successfully completed at least one similar project of aquarium in any government should have any government, state or central government undertaking organization. Copy of the central of the completion certificate or work order is to be enclosed, period. And this, my lords, expression has been interpreted by our own High Court in another judgment. I'm passing on, my lords, 2 copies for your lordships, my lords. Perusal. Similar clause, my lord. Similar clause, my lords. That is page 15, paragraph 8. Your lordship, this judgment, your lordship, kindly come to paragraph, page 15, paragraph 8. For just and proper adjudication of the case, the relevant clauses of the DTCN are extracted hereunder. Clause 6. The firm's company's registered contractor should have executed civil construction work, valuing not less than 154 lakhs, that is 30% of the estimated cost in 1 year during the last 5 financial years. The constructed work should have been executed in government, public sector undertaking, enterprises in India. The executed similar nature of civil works should indicate at least one so and so, my lord. And then, my lords, page 21, your lordship, my lords, paragraph 11, my lords, page, I'm sorry, my lords, page, paragraph 25, page 30. In state of MP versus Lakshmi Sagar Mishra, AIR 79 Supreme Court, while interpreting the words should have worked on the post for a minimum period of 7 years, appearing in Rule 3B of the rules framed under the MP Local Authority School Teachers Absorption Rules 1960, the Apex Court held that on a pure grammatical construction of the expression, it would indisputably appear that the person claiming to be absorbed must have worked on the post of headmaster principal of a higher secondary school for a minimum 7 years. Then, your lordship, my lords, the next page 31. Therefore, by applying the above principle to the present case, if the word should have used in clause 6 are treated as must have, then in that case, the case of the petitioner is well justified because the opposite party number 4 does not satisfy the requirement of clause 6, having not got the experience certificate and documents issued or signed from by the appropriate authority that is not below the rank of an executive engineer or equivalent. Then, my lords, page 38, paragraph 34. Therefore, taking into consideration the judgments of the Apex Court as well as this court, as mentioned above, since the opposite party authorities have come to a conclusion for awarding the contract in favor of the opposite party number 4, taking into account the 2 certificates obtained from private agencies, the same is contrary to clause 6 of the DPCM, whereby the decision-making process is perverse, arbitrary, and contrary to the provisions of law. More so, the notifications dated 24/3/2015 under Annexure 7 relied upon by the opposite party authorities justifying their action having not formed part of the DPCM, the same should not have been taken into consideration. So therefore, my lords, this judgment also has spoken in similar light, my lords, where similar considerations were examined by this honorable court, my lords. The difference is that the danger is the verifiability. If somebody has worked in the government, my lord, it can be easily verified. And that is why, my lord, they emphasize on the stress. Otherwise, normally your lordship will find, my lord, it doesn't come with this the heading. But since this is the special nature of work, this kind of heading doesn't normally come, my lord. And also, my lord, there are tenders your lordship must have come across, which says contracts and subcontractors are also permitted. Those contracts are also there, man. But here, my lords, my most humble and most respectful submission before your lordship, my lords, is that this, my lords, the specification that this is a special nature of work and successful completion of the work order should be enclosed from a state government or a government, my lords, central government agency, would, my lords, eliminate or would exclude, my lords, for whatever reason, a subcontract. Otherwise, my lord, there was no harm in specifying that even subcontractors having work of that, my lord, financial capability can be considered, subject to cross-check or whatever, my lord. Here we don't know, my lord, it's a private agency. And it's a subcontract. So therefore, my lords, by design, they have ignored, my lords. So here, my lords, another category of persons are coming in. So all, my lords, everybody else have submitted government experience. This is the only person, singular person, my lords. There were 5 tenderers who have submitted a private experience and he has been selected. So therefore, it's not beyond the, my lords, private experience is not beyond manipulation. Where is the sanctity, my lords? how does one cross-check? Now, supposing, my lords, how does one cross-check whether the work was successfully done up to the standard, up to the mark or not? That is in a government work, it's easier to verify. Had it been Vania who was competing,
Very easy to.
very easy to verify.
They will contact him.
My lord.
What is there, just to, has he completed?
Now,
Easy.
those other documents and other requirements would be there. GSTN number, this, that, and all that. There'll be a lot of
There.
there'll be other ramifications. Financial ramifications will be different.
Judgment, would you feel that this judgment has a will clinch an issue?
Man,
The division judgment of this court.
man,
Have you seen clause 6?
man. No, sir.
Page 15.
Page 15.
Man,
Look at clause 6. At the bottom.
should include executed similar nature of civil construction work should include at least one 10 KLD above capacity SCTP either completed or the core components of SCTP have been successfully commissioned in any government, public sector undertaking, enterprises in
There is
India.
no private.
No, public sector undertaking.
PSUs are different, sir. It's not a private. PSUs are
No. PSUs are
different.
government.
So they have a pervasive control.
Man, it's Article 12. PSUs would be Article 12.
That's why you pointed out that this private sector has been introduced in this.
This year.
PTC.
In this, because
This
prior
may not be- this may not be-
Governmental proper. There was no difficulty, but once it is included, the private sector, there was remain.
My submission is this manner that the threshold requirement is not met. That is,
You say the special circumstances
yes, that,
once indicated, and then the
Yes.
conditions have been imposed, so it
so therefore,
overrides the general conditions.
it would override the general condition, my lord. It would naturally override the general condition. Otherwise, it doesn't.
Or emphatic, I say it overrides the general condition.
It does not normally come like this. Since this is a special nature of work, criterion have been-
Sir, I understood.
Madam.
What your case is.
my lord, that is where my lord, the entire emphasis is there.
You were correct that if you could not convince, then you go out of.
Well, the general conditions are there. The general conditions are normally there. You file it, you are not automatically disqualified. Along with the private, along with the requirement of the general, at least one, you have to file of the state government or the Senate. And here, my lords, of all the 5 bidders, there were 5 bidders. Only bidder, my lords, who has filed the single, my lords, bidder who has filed only private is this bidder L1. Page 26. Paradigm shift is the game changer.
This paradigm shift can be seen when the private sector is included for the first time. It was not there in the.
When it doesn't come from the record, it has to come from the record somewhere. It has to come from the record somewhere. And also the logic behind this, my lord, also has to be seen equally. Your lordship is, my lord, I will not join issues on that. But equally, your lordship should see why they are writing this. Since this is a
Special nature of work.
yes, so why should they also write that? So that logic also should be equally examined.
In a checklist, they have not corrected it.
Corrected it. It may be remained in the
Why?
checklist. Why should they specify
The
this thing?
checklist talks about the
Maybe,
private,
Man,
sectors.
maybe.
certificate.
I'm just it's just a random thought, man. Maybe some experiences with the private parties in the past might not have been very pleasant. So therefore they have said, no, we will only go in for persons who have had experience in government contract. Maybe. It's also a permissible manner. It's just a random thought that strikes me. Because of this, what manners persuades me to think that way is this, that why should they introduce this suddenly in this tender? It is not
Casus omission,
Manners.
not a casus omissus.
No, it's a conscious insertion. It's not a cautious omission, it's a conscious insertion. Just the reverse. And that normally doesn't happen, my lords. Had it been a casus omissus, as your lordship is saying, my lords, I would bow down, my lord. But this is just the other way around. No? This is a deliberate insertion. And they specified, we only need this, and we don't need anybody else. And this. And so everybody who has come, I would also, another random thought strikes me since we are, my lord, in the picture of the discussion, my lord, that had you specified, maybe we would have got better offers from other private players. Other such parties would have given more, my lord, financially.
There is nobody who has come forward.
Nobody has come forward because of this. Because of
How can you presume?
that presumption comes strongly because of page 18. Well, normally when you go for a tender, you don't look at the annexures.
Yes, you have to
Well, normally
bit of the.
with my limited experience, my lord, in handling these kind of matters, normally you would go by this. Normally you would go by page 18 and you'd go by page 21. You would not go by an annexure. Normally when you're looking at it, you will not go by an annexure.
Are you talking, sir, in a tender document, more careful,
There's one more
they
judgment.
scrutinize 7 times before submission.
Absolutely, my lord. Absolutely. I bow down.
If there is any minuscule defect, my tender would be rejected.
Well, there's one more judgment for your lordship's perusal, minutes. Paragraph 16 is what we would be relying. Vidhanva. Vidhanva. 20. It is clear, even on a reading of this judgment, that the words used in the tender document cannot be ignored or treated as redundant or superfluous. They must be given meaning in their necessary significance. Given the fact that the present
I understand.
months.
There cannot be substitution, addition of
Man,
any
that,
words.
and here, Manas,
Now,
special terminology has been
then
issued.
I'm posing a question.
Mine.
There appears to be a disparity in
Mine.
one clauses with the another clause.
Man,
What is the interpretative tool which should be applied?
Manas,
One would come earlier or later. In the interpretation of the statute, things are clear. In interpreting the contract, what should be? If there is no symmetry between an earlier term, the clause, and the latter clause,
man,
then which one should prevail?
that which more, I might be subject to correction by your lordship. I would, submit that which more specifically spells out the intention of the contract should be adopted. That clause which spells out more specifically the intention of the contract should be adopted. Here, the intention of the contract can be called out from the
So
invitation.
it appears
The invitation.
if a particular word is
Correct.
appearing in several other clauses except the one,
Man,
then what intention a person should gather?
here the repetition is there. Here,
I'm simply asking because I find that more than one clauses contained a particular, the private sector. Only one clause does not contain the private sector.
here it
Then
is only
what
the
would happen?
checklist.
What should be the intention?
Here,
We
it would,
can
of course,
gather.
it would depend on the context of the tender. What is the tender that is being, what is the
There's no safest way
contract?
of moving.
But what is the contract that is being, it also depends on the nature of the contract, Manoj. And
But
I'm now
on
we are-
commission,
I'm
there
going
can
back
be
to
one-
law
one-
school again,
one
I'm going
mistake.
back to law school again, Manoj.
Mistakes at the same time. There can't be a
My submission is this, my lord. I have the invitation can be culled out from this, my lord. Invitation
What is the difference of the price?
4%, not much, only 4%, hardly anything. There's hardly a difference, but so that's why I started saying that I'll match that price. Now, my lords, the intention is here, my lords, that I invite a bid and I
Anything more, I think.
No, madam, this would be my submissions.
So what do you say about it?
I've already pointed out that there.
No, this is not a pointing out. He just pointed out, he's saying is that there is a one broader heading which says that because of the specialized character of a job or a work, so these are the special conditions which we are imposing.
Aquarium maintenance work, it is more of a manual work rather than any very specialized work.
They have incorporated that.
Yes, my lord.
So that reason, aquarium does not mean only the change of water, the feeding of fish.
No,
You
my
know
lord.
which fish should be fed, how
Yes. So for
and
that,
then you should know that
No, my
one
lord,
is sick
in
or
the- as
one
on-
is not sick.
my lord, as on day, rather than in the public sector, in the private sector, there are more aquariums which require your lordships. I've seen in almost all the tourist places. These are all privately held
Now,
aquariums where.
the contract, the tender document, if there is some kind of a, I would say, disharmony amongst the different clauses, then what should be the interpretative tools the court should adopt?
Rather, my lord, I would rather say that it should broaden the scope of competition.
This can't be. This can't be.
Because by including consciously
This
the
cannot-
private sector,
This cannot come. What is the law? Tell us. What should be the law?
my lord, which brings in more competition in a process and the prices will come down. That is what the very intent of it. And that is why the private sector was included this time. Earlier, it was never there. This is the first time they have included, and specifically in the checklist also they mentioned that. Not in the general terms only, because checklist forms part of the detailed tender document.
It could have been spelled out more prominently. Could have been spelled out more.
After all, the ball is rolling in our court.
Madam, squarely the ball is in your lordship's court,
Work
madam.
on this and we'll have to decide.
It is now, madam, squarely in your lordship's court.
Once instruction, your lordship, just gone for vetting for a counter-affidavit. They have put it in that instruction that the schedule 1 forms part of the DTCA, so does the checklist, your lordship. And the private parties are included in this contract for the tender. And also the fact that before each bid, there is a pre-bid meeting, your lordship. If any clarification the petitioner wanted as to the checklist and to the schedule 1, they could have clarified at that point of time. After participating in the tender
In a pre-bid
meeting.
meeting.
Yes, sir.
So, there cannot be any occasion to anticipate that somebody would, from the private sector.
Your lordship, they have to go through each and every line of the tender document.
That is true.
Yes, your lordship, they could have clarified from the authorities whether the private individuals, after participating in the tender, after having failed in the tender, they come in here, your lordship.
This was discussed and it was agreed that yes, they can also.
They have not raised the issue there, your lordship. They have not raised the issues with the authorities.
Has raised, no.
They have not raised. No, one has raised it.
Might have raised, there are 9 bidders.
In the pre-bid bidding, there has never been any objection to our participation.
Any discussion in it.
There's no objection to our participation.
But even the difference.
So it ended with a smile with a cup of tea.
These are, your lordship, these are kept only for their clarification of all those people who want to bid, your lordship. If they don't clarify themselves, your lordship, and they
If
come
they
after
wanted a
participating.
clarification, they could have asked us. If they found any discrepancy in our document, that is the pre-bid for.
Even with a tender document. Even with a tender document.
Before you make your
Yes.
bid
Yes.
submitted, they give any ambiguity, any kind of confusion that has arisen.
Bidder has to make the claim.
You can just place it so that the clarity may come in there. So that is what is an object of the bid. Otherwise,
I leave it to your lordship.
Item 42, the lordship should be kind enough to let the fixed date in item 42. 8th of August. 8th of August, because we come from August.
his name,
Readings are still to be completed.
It's Friday. It's Friday.
Friday is not possible.
We'll give a convenient date to the court. And interim orders to continue.
Friday is again a second bench and all of it.
We'll take our chance to it. We'll take our chance.
Residential house of the afternoon will be demolished by law.
Because there was on 2 matters consumed the first.
That's right.
And it has to be dictated in the today itself, otherwise it will become. So that is what is the difference. No, if it is a consensus of the bar that previously if there is any order passed for listing of the matter tomorrow, we will not list it tomorrow. We will continue with the list. If it is a consensus of the bar. Yes. So don't list any matter tomorrow, which is fixed for tomorrow.
Yes.
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 Let's do.
Yes.
Item 9 is a cover matter.
42 to be adjourned to any other date. Interim orders.
Cancellation matter.
42 to be adjourned to a date. And interim orders.
Keep it on 7th, can't we keep it on 7th? For others.
Yes.
One day before, 8th.
Because of my.
8th, Friday is a dicey day.
We'll
That's why
take
I
our
said
chances, we'll take our chance.
keep it on Friday because
We'll
we
take our
have
chance.
a split bench a lot.
But sometimes in splits, we can make up.
31
Interim orders to continue.